পিসি গুলো এটা বন্ধ করে দাও, 24-25 করে দাও। বন্ধ করে দিই, বন্ধ করে দাও কাছেরটা, বন্ধ করেছে, তারপর গরম হয়ে গেলে তখন বন্ধ আছে। ইয়েস,
We also kindly leave to mention, my lord, this bench matter, my lord, the my lord Justice, Chief Justice, and my lord Justice. This field matter, my lord, this matter is appearing, my lord, on the Thika property. Construction is unauthorizedly going on, my lord, top of the sixth floor is going, fourth floor. It's going on, my lord. In the locality, as a problem has been created.
motion.
My lord, when have you filed? My lord, it is appearing in the list, my lord. For my lord,
the list under the heading motion or hearing?
Motion.
Motion.
My lord.
It
Item
is
number
appearing,
not
will be
taking
taking up.
taken up.
My lord,
Will be taken up.
List will be called on.
Permit us to call the list.
What is your item number? What
It
is
is
your
appearing in our
yesterday's
list.
list. But it is in the yesterday's list.
Yes, it is appearing in our list now today.
Public interest litigations are taken up on Thursday. That is why hand over the slip will
My
come.
lord, that's why today's is.
My lord, may I permitted to mention one matter of my lord Justice and my lord Shampa Datta Pal, my lord. This is a contempt matter, my lord. My lord has passed.
এসছেন, উনি তো বাইরে ছিলেন না। হ্যাঁ, আছেন এখানে, জিজ্ঞেস করে নাও, দরকার নেই, একদিন যে কোনো দিন।
Lordship, may I have your lordship's kind leave to mention a matter? An order 41 appeal and an application connected.
This is not a bench. Come at 2.
Very good. My lord,
Oh, ঠিক আছে।
My lord, may I be permitted to mention, my lord, for inclusion of my lord, for passing application for appropriate orders, my lord.
Connection with what?
In connection with my lord, CAN 7 F8 317 of
Connection with what
2013.
matter?
My lord,
This bench is especially constituted for Chief Justice's determination. Is it pertaining to that determination or a regular determination?
my lord, regular.
Then
My
come
lord,
at 2.
it is appeal has been disposed of, my lord. For the decree, my lord, there is a since
That is
appellant
not a
died.
bench. The other partner is not here. Come at 2. We'll be sitting from 2.
Great.
Call the list.
Lord, I am for the petitioner. The petitioner doesn't want to proceed with the matter, my lord. Well, here the written
What
instruction.
mentioning?
Written instruction doesn't want to proceed with the matter, my lord.
Okay. The Chief Justice's determination. They get right.
Do not want to proceed.
Yes, my lord.
You have the written instructions from your client.
Who has signed it?
Lord, the petitioner, my lord.
No. His name is Amit Tulsian and his signature is Amit Kumar Tulsian.
The same person, my lord.
Oh, he has not. A affidavit to the how he has affirmed. Cost title says Amit Tulsian. He is not using the word Kumar. Wakalatnama signed as Amit Tulsian.
The affidavit, my lord, lordship will find Amit Kumar Tulsian, I think.
Oh, alias. Alias. What is this? Sometimes write as Amit Tulsian, sometimes at Amit Kumar Tulsian. What is this?
The honored advocate appearing for the appellant
You are the advocate on record.
No, my lord.
Who is the advocate on record?
Lord, Mr. Torunjit Tiwari.
Where is he?
Lord, he's on his leg before court.
No, the withdrawal cannot be done. Withdrawal should be done by an advocate on record. He must owe the responsibility of withdrawal. Call him. Oh. ঠিক আছে। Has been conferred a senior ground now?
No, my lord.
No. No. Then where is he? Call him. Okay, take him. Have you got a record? That's my list. Yes, filed a Mogalatnama, he should bear the responsibility. Call him.
Ask him to come.
Speak to appear for the petition. তোমার কোথায় আছে? কোনটা কোথায়?
Will the affidavit by the respondent? And
Till now, my lord, no filed by
have you given an intimation? This was
Well,
appearing in the list or
my lord, I have
appearing has to be mentioned?
given my lord intimation.
Who is appearing for the state?
My lord,
Mr. Kaivalandu Bhaumik for respondent number 6 and Sunit Kumar Roy for National Medical Council.
and my lord, from the state, my lord,
Your Lordship,
last order,
Where is a notice?
learned, my lord, this senior standing counsel appearing, my lord. This Amitesh
I'm led by
Banerjee.
Mr. Amitesh Banerjee, Your Lordship. The notice was not served, so we are not.
You have not
How-
served notice.
However, it is.
My lord, I have served, my lord. Kindly
Mr. Amitesh Banerjee, you have not served.
No, there is no tick of Amitesh Banerjee.
on
It
his
appears
behalf,
that
my
you have given it to,
Mr. Shoibalandu Bhaumik.
no, he's a,
Shubha Dadok. Oh, Shubha Dadok is assisting Mr. Banerjee.
I am assisting. Notice was not served, but however, to make life easier for
No.
every.
no, somebody, Husendru Das, something. Your clerk has.
No,
received.
Your Lordship, he is not my clerk.
Who is he?
I don't know.
lord, he, my lord, claims that he's the, my lord, this
No.
associates of me.
Look at it, the signature.
But he is the clerk of another junior of Mr. Banerjee who is not there in the matter. Lordship, however, the affidavit is ready. Lordship, give me 1 day's time. Monday it will be affirmed, Your Lordship. It will be affirmed on Monday. It is ready. It is approved also. এটা না আমি জুনিয়র আছি দাদা সাথে তো আমার নাম আছে হ্যাঁ সাথে তো বিভিন্ন
My lord, I am appearing for the petitioner, my lord. This is a contempt application, my lord, of the order dated 11/11/20
Item number,
3 and 4, your lordship. 3.
contempt of whose order?
My lord, the Chief Justice and my lord, your lordship.
Oh, then let it be taken up by that bench. It has to be taken up by that bench. Let that
Lordship.
bench come.
Lordship.
Hey, the instant matter pertains to the
Kagoz.
alleged
Ballot in this matter, Mr. Sarajan appearing behalf of
to
the.
be mentioned. What are you talking
But
about?
no, but his maternal
Adjournment,
uncle,
Passover.
but
is
due to
to
death
be
of his
mentioned.
maternal uncle, Malad, he has come to the court, Malad.
Whatever.
Matter relating to deputy appointment of the deputy
And we are directing this matter to go out of this. Let it go out of this. Solve litigation. Why the
Well, I'm paying for not today. Paying for not today, Malad.
no, not today. What is this?
But Malad, due to death of his maternal uncle, Mr. Jahan, Malad, Mr. Jahan not appearing in this matter. But I am not at home on record, Malad. He has informed me. Not seeking to.
The adjournment is sought on behalf of the appellant. Let this matter go out of this. And be listed before the regular bench.
Regular bench which you assigned.
Item number 6, my lord. Putiba horse. Putiba horse. My lord, item number 6, my lord. Mr. Rasdeep Bhattacharya is appearing, my lord. He has not been able.
48 days delay, section 5. Have you served the copy?
My lord, we have served, my
Where is
lord.
the affidavit of service?
My lord, this is my affidavit. My lord, I'm late by Mr. Bhattacharya due to some.
Whatever,
My lord,
where is the affidavit of service?
my lord.
It's for the other side.
Due to sir. Due to
It's for the other side.
my lord, this is appearing for the first time, my lord. My lord, Union of India, my lord.
Inspector General. I think the Union of India has an office. Why don't you serve a copy on in the office? Why you are sending it by post?
My lord, then I shall take endeavor to again serve, my lord.
That's why you are able to do.
My lord, we tried, but they refused, my lord. That is the reason, my lord. We have tried, but they refused. They told us to.
How can they refuse?
My lord, as that is the reason, my lord, we had sent it.
All is or a deputy solicitor general, anybody is available.
My lord,
Who appeared for the Union of India before the learned single judge? Mr. Devopriyo Gupta.
my lord, kindly give me a moment. Yes, my lord, Mr. Devopriya.
Serve him.
Then I shall again serve. Get it.
Now, if you are saying that they have refused to accept, call him. See that why they can refuse. Just go and call him, the pass over. Item number 7.
My lord, this is my appeal. This has not been heard before, but my lord,
Because you asked for an adjournment, joint prayer for adjournment.
yes, yes. And so, my lord, the short point involved, my lord.
Very difficult when you use the term short point.
When it comes to your lordship, it becomes short, my lord.
Sure.
Everywhere else, it's length. My lord, I have compromised with the bank, my lord. I have paid the entire dues. The TRT proceedings have been withdrawn. Money has been taken by them. Now, my lord, the criminal proceeding, my lord, was initiated, which, my lord, I only made the bank aware of that I was cheated by a third person. But, my lord, they did not believe me and they initiated the criminal proceeding. Today, I am before your lordship to say that, my lord, this now continuation of that, my lord, causes me grave prejudice, injustice, and, my lord, it is an abuse. And, my lord, your lordship also knows, my lord, I'm fortified by recent 2024 also, where Supreme Court has said, even if Prevention of Corruption Act is involved or anything has been, my lord, indicted on that, my lord, it can be quashed. It has said that. And, my lord, today, no charge sheet has been filed. Only this FIR, my lord, pending for so long. And, my lord, I am not a huge businessman, my lord. Whatever I had given. I, my lord, don't want to continue with all these my lord, litigation. Now, this is the only point. And the two judgments today I'll show. Now, these two judgments were not there before the learned trial judge, my lord, when I had argued the matter. The law then, my lord, was decided, my lord, in Nikhil Merchant. And then, my lord, the three judgments referred to a full bench, which was, my lord, Gyan Singh. So that was the law then, which on the basis of which I went. In the impugned order, my lord, his lordship felt, my lord, there is this is not a fit matter where it can be quashed. And there is also, my lord, willful defaulter proceedings were before me without my knowledge. Now, since it's settled, my lord, I have not challenged. But I don't want to challenge that today, my lord. I want to come out of it. Kindly, my lord, if I may show.
Madam, the first question
Yes.
is the appeal maintainable? View of clause 15 of the notice petition.
This is the original side, appellate side. So this is appellate side, my lord.
Please consider Ram Kishan Fauji's case of the Supreme Court.
More particularly considering your prayer A of the writ petition. Whether the order passed should not be treated to be an order passed in exercise of criminal jurisdiction.
Do you have the copy of the notice petition?
Let us put in turn off. Lord, I don't.
Number 2.
There is.
Prayer A in the writ petition.
You have gone to a writ court for quashing.
Yes, my lord. Under 226 jurisdiction.
Correct. Can you do it? Because there are provisions under the criminal procedure code that
Oh,
you can
that
go for.
also. Yes.
And then if you have gone for a writ is maintainable. but whether the appeal is maintainable against the order of the single bench.
My lord, if writ is maintainable, my lord, I can show.
But the appeal is
Whether
maintainable.
a
Like I know, we are conscious
Yes,
writ
yes,
is
yes.
maintainable. But whether the appeal is maintainable under clause 15, let us
Clause
fit in,
15,
don't you have?
Well, I'm bringing. Well, because I have seen Supreme Court deciding an appeal.
I am giving you a Supreme Court judgment which says that no, is a Ram Kishan Fauji's judgment.
There are two division bench judgments of our court also.
Not maintained. Then, my lord, is it straight to Supreme Court?
That is, you have to argue what should be the.
Yes, I want to hear. Very well. I'll.
Where is that judgment? Well, find out. You are all tech savvy and you
No,
don't
that-
know Ram Kishan Fauji's judgment.
Yes. কি করছো আমারটা কোথায় এসসিসি তো বার করো Well, I'll take out. But today only, my lord, I am not that equipped and
Today, it's a question of
competent to get ready and
It's
answer.
Maintainability has to
question
be
of
answered.
jurisdiction. If the proceeding is not maintainable on the face of it, any order passed in such proceeding, apart from dismissing it as not maintainable, will be a nullity without jurisdiction.
I'll come back. So I'll consider that. Writ is maintainable, I'll show.
Appeal is not
Appeal is
maintainable.
not maintained and only will restrict me to that. Now, my lord,
But if
going
we are
back and
restricting to
saying
that,
it is-
we are not pointing out that the writ is not maintainable. No,
Yes. Writ
it may be
is-
maintainable.
Yes. We proceed on that.
But
basis.
whether appeal would lie,
Yes. Only that. I'll
he has
come
not
back.
taken a point.
They have not taken any.
So-
Yes, they have taken the money.
So slate face, he has not taken a point.
But he has
Have you
taken
found
the-
out
Yes,
Ram
sure.
Kishan Fauji's judgment of the Supreme
Sure.
Court?
এই তো। 17 এ হবে। Yes, it's 17(5) SCC 533.
What is held there?
Let us patent appeal non-availability of in cases of orders made in exercise of criminal jurisdiction.
Yes.
Yes, under Article 226, read. That also originates from
Ten,
226.
The Lahore High Court's letters patent, which is pari material to clause 15 of the High Court letters patent. Non-maintainability of LPA against letters patent appeal against judgment or order under 226. Quashing FIR instituted person.
That was your prayer before
That
the,
was your prayer.
before the
portion
writ
of the
court.
FIR.
I'll come back. Give me some time, Lord. Every time I come, Lord, I learn something
What law?
from your lordship. Yes,
Read the judge.
I'll read, Lord.
But it a caution. So horrible. Yes, no, caution. Not caution. Look for the 9 to 13 around or this was.
This might, Lord, this was 2017 considering Lahore. Maybe, Lord, if I have some.
Perimeteria with Article this
Yes.
clause 15.
Yes.
What are you talking about?
No, I'm saying if there is something, it will
Supreme
give
Court
a
has
lot
said it is perimeteria.
relief.
That's why I wanted a clause 15 to be read. Within bracket, I believe, if my memory goes right,
Something
it
in
says
brackets.
criminal
Yes,
jurisdiction.
absolutely.
And this judgment was considered by two coordinate benches.
Of our High Court.
Yes. One presided over by Justice Radhakrishnan and Justice Arijit Banerjee. Authored by Justice Arijit Banerjee.
देखो ना,
The other
The second one is
presided over by Justice Talukdar.
Justice Subrata Talukdar.
But my lord, on a broader picture, this
conflicting
should not be the law because my lord,
what?
because lot of litigants, my lord, may not have the means to go to Supreme Court all the time.
You are bound by the judgment of the Honorable Supreme Court.
The lordships will reconsider in that light today.
We also consider that by passing the statutory provision and invoking an extraordinary jurisdiction under Article 226, that should also be taken into consideration.
Whether you can get a further right of appeal,
You
which
can
is
go
not there.
under the criminal procedure code, earlier one, 482, you can come for a quashi. By passing that, whether the writ.
Only to get another remedy before the High Court.
No, 482 subject to correction and 226 have the same my lord parameters.
Because of the distinguishing features. In 482, if the court exercises the power, there is no further appeal. You are taking advantage of 226 and then having an intra-court appeal and then going to the Supreme Court. You are having two tier of filtration.
Before the High Court. Whether you can do that by choosing one forum or one form of remedy.
Not so easy, madam.
Abuse of process will not want.
Not so easy, madam. That is the whole thing.
What will happen whether you have a further right of appeal, that is to be decided.
But then again, I'll go back to maintainability of the writ. I don't want to
No,
go there.
that's why I'm saying. The court has said that yes, alternative efficacious remedy may not be an absolute bar.
Yes.
226 is maintainable, but since in a criminal jurisdiction under 482
Yes,
no appeal lies, then the Supreme Court says that why you will be given a premium of one appellate remedy. You should also go straight away.
That will seem. I'll some research your lordship will.
I gave you the research
No, I'll
paper.
come back. There are other things I have to consider. This
Some
is-
inputs on that research we have given.
And your lordship.
Two things you have to, this judgment and your first prayer.
Yes, I'll consider.
Your first prayer in the writ. Quashing of.
Washing I have asked, even though under 220 this window. Yes, I'll consider. And I'll come back.
Further research is required.
No, I'll come back and answer, my lord. I want your lordships to take a pragmatic view and write a judgment where I'm arguing, my lord, a point of law.
Let us patent our
Let us
দরকার
patent.
তুমি এটা দিয়ে বুঝে পাচ্ছি
Clause 50. I have.
point out the let us patent open clause 15.
Yes,
Where is clause 15?
page 19.
Look at clause 15. কোথায় আছে? Let us patent নেই ওটা relating to procedure under appeal. আমি চাইছি যে clause 15 টা কোথায়?
Lord, I have it. Are we in?
It says that
Hmm.
and we do further ordain that an appeal shall lie to the said High Court of Judicature at Fort William in Bengal from the judgment not being a judgment passed in exercise of the appellate jurisdiction in respect of a decree or order made in exercise of the appellate jurisdiction by the court, subject to the superintendence of the said court, and not being an order made in exercise of the revisional jurisdiction, and not being a sentence and an order passed or made in exercise of a power of superintendence under provision of 107 of the Government of India, in exercise, then it says, what is that? In exercise of criminal jurisdiction of one judge of the said High Court or a one judge of any division bench pursuant to the section such as that. So it is in exercise of the criminal jurisdiction. Ramkrishan Fauji says it's exercise of criminal jurisdiction.
I'll see. But that is criminal completely. But if my criminal matter has some civil facets,
Better read carefully that judgment
That
of the
can be
Supreme
listed.
Court and then argue something. You are arguing in air.
yes, I'll come back. That's what I'm saying. I'll show Milord because these criminal proceedings,
Please read the
I-
judgment. You have not read the judgment.
I'll come back.
Whatever you are arguing has been repealed, displaced by the Supreme Court.
I'll consider that in detail.
Complete exercise of criminal jurisdiction, hybrid exercise of criminal jurisdiction, everything was argued.
One chance today.
Come on Monday, weekend you enjoy
No.
on a research, come on Monday.
Milord, any other day, Milord, apart from Monday, Tuesday, Milord, I will. I'm not that busy, but that day only, Milord, I have to go to Delhi, Milord. Milord, Wednesday, Thursday, Friday, Saturday also I'll come.
Native place.
Milord,
Prefer native place.
Milord, any day. Even Saturday I'll come. (16) next Monday or Milord 11, 12, 13. Kindly. Yes.
Yes. On the point of maintainability of an appeal under clause 15 of the letter specifically, the counsel for the appellate is for an admonition to ponder upon the said issue, said point. Let this matter be listed on next Wednesday.
Deeply open.
Yes.
I'm grateful.
কবে লাগলো কবে কবে লাগলো কবে
Bank.
Same. Actually, the criminal by an RTR order would be after that.
No application नहीं no application नहीं
So he is not interested. None appears. Let this matter be again listed on next Wednesday.
Buying agreed. On the last occasion, there is a direction upon Joynagar police station, to file a report. It will come back, to Justice Bhattacharya's mind. There was, a writ petition filed, by a tenant, alleging that, the landlord is not supplying, or has disconnected electricity. Now, this alleged tenant was, running a recruitment racket of my lord government job from my premises. And my lord, there were allegations galore, my lord, FIRs were drawn, my lord, he was picked up, my lord, by the police authorities. So my lord, the Honorable Chief Justice was, my lord, of the view that, my lord, if he is doing this kinds of activities, then, my lord, he is not entitled even, my lord, to electricity or, my lord, to occupy the premises. And, my lord, the premises was not. That is what has so far happened. Now, a report was called for from the police authorities. Police authorities have already submitted a report saying that there are multiple FIRs drawn against him, and those criminal proceedings are pending. Now, what happened? When the puja vacation was knocking at the door, he prayed for a mercy, and only because of this ensuing puja vacation, the stay initially there was a stay granted, that was lifted for a limited period.
What
Due-
is granted?
Of the order passed by the Honorable Single
What
Judge.
order was passed?
The disconnection of electricity, no, restoration of connection of electricity, there was
New connection.
Disconnected.
New connection. New connection.
their allegation was that I was not supplying electricity as the landlord.
So disconnection was at your behest.
That was the allegation.
What is your stand? You are
My,
the landlord.
I was I never disconnected
Then who
electricity.
disconnected?
That for them to establish.
You are directing the Electric Supply Corporation to find out that who disconnected.
No, disconnection was made by them. I applied for new connection. That was given to me by virtue of the order of the court. New connection.
He is now enjoying electricity, but in the meantime, he again started those mischievous activities, pelted stones at my premises and all that. So a report was called for on 20th of November from the Joynagar police station. That report possibly has not come yet.
Yes, my lord. I am appealing for the state, my lord. I have reviewed the report, my lord. Earlier, there was a report in the form of affidavit.
I just indicate one more thing. What this gentleman has done in my premises, all around, he has hung up portraits of political leaders. He claims that he is an influential person. Taken money from so many persons. On an assurance that he will secure a government job for them, which he has not been able to do. Now those people are continuously coming. Once picked up his two-wheeler. He was bitten. Then FIRs were lodged. These premises, I say, Mr. Mike.
Then he does not seem to be an influential person. If somebody, a rank stranger, came and beat him up.
It was a mob. It was a mob. It was a mob. That's what I know. It was a mob. So many persons. And all around he had hung up portraits of political leaders just to influence people that he has some influence, he can shake your job. This is what is being done from my premises. I requested the police authorities come inspect.
Why you are displaying? You are for the tenant.
I am for the tenant, my lord.
Why you are displaying?
Your lordship, kindly see to that extent. Is there any aberrament to that in the memo appeal? Nothing was displayed.
We are directing the inspection. If we find that these are all
I am deeply obliged. My lord, nothing on.
Premises be there.
Yes,
You cannot encroach upon any other portion of the.
nothing, my lord. I am deeply obliged.
Why?
I am nothing, my lord. Your lordship, kindly see the in their opposition, in the reply also they are not mentioned any document, scrap of document.
Records are
4
there.
FIRs was lodged, my lord. The 4 FIRs lodged at the instance of him. 3 FIR.
Sir, you are a tenant. Be happy with the tenant.
My lord, I am deeply obliged. I am no.
Sir,
Yes,
you cannot go beyond that.
no, my lord. I am not, my lord.
A civil dispute.
Why you will display all these things? That's not your property.
My lord,
That's the property of another person.
my lord, your lordship, kindly see, my lord, is there any document to the extent, any photographs to that extent? Nothing. Only from the bar. Kindly see, my lord, in the opposition.
Show us some evidence.
Every evidence.
Show us.
My
Show us.
my lord,
Very bold. Let us see.
Yes.
my lord, after
Kindly
the
take
report,
minute.
my lord, kindly go through the report, second page, my lord. There were series of allegations and FIR.
At the instance of
my
the-
lord,
That we have seen, madam. There is
is a
FIR,
further
counter
report, my
FIR, everything has come.
that is the respondent.
Where is the
petitioner.
Photograph, my lord, we could not.
Why could not?
Photograph, my lord, we could not
Displayed
take.
around your property, will you not?
It's within his, my lord, device premises, my lord, inside.
Might means what?
It's a room.
Inside,
It's a room. Yes.
then why?
My lord, I could not take
Then-
photographs.
then
I could not take,
why?
but my lord, I have averred that. I have
No.
averred that.
No,
Kindly.
I can display anybody of my choice within my room.
My lord, those are being displayed for the purpose of taking money from
Sir,
people, my lord, on an assurance to give government
Sir,
job.
that is a criminal investigation that will go on.
That's being done
What
from
I am
my
doing, I
premises.
can display the photographs of my grandfather. I can display the photographs of my father. I can display the photographs, whatever,
Absolutely,
of my
absolutely.
godfather.
My lord, not to do any
Whatever.
illegal thing. And it's being done, my lord, from my premises. My lord, every time
projected-
mob is coming.
You told us as if that around the entire.
But that's
property
what, my
was
lord, the
removed,
petition says.
They have displayed.
That's what, my lord, my client has averred.
No.
Kindly see any amendment to that extent.
If it is wrong, then we'll record that you are not a truthful person. If it is not, now you say inside his room.
Yeah,
Then do
inside,
it.
inside.
Inside the room, he can do it. Where is the difficult?
My lord, inside the room, my lord, those are displayed only for the purpose of, my lord, doing
Sir,
this
how do you
mischief.
know? How do you know? It's a criminal investigation which is going on.
My lord, police has said, not, my lord, about the photographs, but, my lord, police has said that, my lord, there are allegations.
আমি কার ছবি লাগাবো তার জন্য কি বাইরের লোক বলবে যে তুমি এই ছবি লাগাবে না? That's absolutely invasion of my privacy.
Absolutely, my lord, but not for some illegal purpose, some mischievous
How do you
purpose.
know it is for the illegal
My lord, the
purpose?
police complaints are
Whatever
there.
the complaints have not fructified into a charge sheet.
That has
My lord,
The
he has,
prima facie,
my lord, I am told
there
he has
will be a
been
lot
charge
of
sheeted.
complaints and ultimately
But I'm-
the investigating officer will say nothing has come.
My lord, I am told he has been charge sheeted also.
in one case, my lord.
He has been charge sheeted.
Displaying this.
No, not for
Then-
displaying photographs, but my lord, for
So
this illegal
you
activities.
Something
Yes.
which does not born from the record.
Miss Avert.
You said in the manner as if the entire your whole property is covered with the photographs.
Under his
or the-
occupation, my lord, he has done so.
That's his property. You have given him position.
My lord, this should be, my lord, sealed by the police
Why?
authorities.
Only thing is not for the any illegal or immoral purposes.
Absolutely, my lord, I am on that. I am
That's
on
not.
that.
Then it's a ground for eviction.
He has filed a suit for
My lord,
eviction.
suit for eviction is ongoing, my lord, that's ongoing.
Banerjee, can you expand the scope of the appeal? What was the
Completely
scope of the
civil
writ
dispute,
petition?
my lord.
With the
That was
restored
with regard to
connection of
connection
electricity. Absolutely.
So can you expand
Absolutely.
the scope of
My lord, what
the
I was,
appeal?
my lord, trying to impress upon your lordship is
Nothing.
only this, that, my lord, electricity cannot be
took it
supplied
very
for doing any
seriously
illegal.
when you said so. When you said, we took it very seriously that this
Yes.
can't.
My lord,
happen
that's
like
what,
this.
my lord, we have said in the
No,
petition
This
also.
is not a correct. Now you are saying inside your property.
It's,
And then the scope of the writ was only the restoration of electricity.
my lord, electricity for
connection
the purpose of, my lord,
given.
perpetuating illegalities.
Where is the prayer for in the writ? Illegalities?
My lord,
Lord,
my lord, even the
Where is the
state,
prayer?
My lord, he was the
my
writ
lord, even
petitioner,
the
I
state
was the
petition is
private
there averment.
Electricity changes.
Well,
How can we go into
My lord, even in the state petition, is there any averment to that extent? Even state petition, my lord.
Don't say. First mend your conduct. There may not be a devastating fire, but there is a spark. Why the mob will come and chase you?
My lord, I am deeply obliged, your lordship. Kindly see that any state petition, is there any averment to that extent also? Is there is a mob? I am proving.
Not, have you not gone there to lodge a complaint?
But it
My lord,
can't-
Must
there,
have gone
my lord, there is,
and
my
lodge a complaint
lord,
that
there is the
somebody has
four,
come.
my lord, there is the 4 complaint lodged by 3 by him.
It's not, my lord,
Three.
against the
I know. There is no above, there is no truth. Then why you have gone to police to lodge a complaint that somebody mob has come and beaten you, assault?
My lord, to that extent, I have no knowledge with regard to the complaint. My lord, the 4 complaint was lodged against me, 3 is lodged by him.
My lord,
3
police
is
has
lodged by
filed
him
an
and
report.
1 is complaint is lodged against by another person.
How many complaints you have lost?
Against to him.
No, whatever. How many complaints you have lost with the police?
No, kindly see that.
Police said many complaints have been lost.
No. My lord, the complaint is lodged
And
against
the
me.
writ petition is affirmed saying that he is a cultivator. But he is a
He may be a cultivator of the innovative ideas. How can you say the cultivator word? You can't squeeze it. He can cultivate innovative ideas.
He's cultivating something at my
Development
premises,
of
my
the
lord. That's the difficulty. He's cultivating those things, my lord, at my premises.
Why not? The invention came from the another premises.
My lord, I'm really worried, my lord, with this tenant. My lord, I'm really worried. My lord, anytime anything may happen, my lord, the way, my lord, he has spread his name, my lord.
But that you have to take appropriate
The
steps.
suit for eviction is, my lord, going on.
Scope of the writ is very limited.
Really?
Necessary. Steps. Need to say.
What is the stage of investigation in respect of?
My lord, the charge sheet has been filed in respect of, my lord, in the third page, my lord. The second page, top. In respect of the complaint lodged on 7th August 2024, at the top of the second page, my lord. In between, it is charge sheet number 684 of 2024, dated 28th September 2024, under section 126 to 115 to
Page number 3.
that is, my lord, case number. Yes, my lord, this is the case number first, my lord, Joynagar PS, case number 634. That charge sheet has been filed, my lord.
So, my lord, police
And
is
other-
also saying the same thing.
Respect of other, my lord, the present one, after the filing of the report in the form of affidavit by the,
No, in page 3 of your report,
yes, my lord, that is, there are 3 cases, my lord. That is the same case has been repeatedly, the 1 and 2 are the same case, my lord. In the 1 and 2, my lord, same case, the charge sheet has been filed against that case, my lord. And the third one is the another case in another PS, my lord. We have obtained that information that has been filed, my lord, which is on record. And the lastly, my lord, 2 complaint has been lodged by either of the party, my lord. One is by the appellant and another by the respondent. That is going on, my lord. Investigation to that aspect is going on.
Seventh August complaint was with regard to, my lord, the recruitment scam. And now, my lord, he has been charge sheeted. My lord, I have the documents with me.
what is the case pending before the civil court?
My lord, it's a suit for eviction, my lord.
You have filed, that is pending.
Yes, that's pending.
476 of 23,
Yes, my 2024 suit.
23 suit.
Oh, no, yes, 746 of 20. No, my lord, that is his suit for declaration. My suit is of 24 for, my lord, eviction. His suit is, my lord, 746 of 2023 for declaration. Both are, my lord, pending. But now police has charge sheeted him, my lord, with these allegations. And these are all done, my lord, from my
That
premises.
will take its own course. Can it be a ground for denying electricity, Mr. Banerjee?
Electricity, my lord, one cannot, my lord, claim a right subject to, of course, correction by lordship, my lord, to perpetuate illegalities.
What are you talking
My lord, to
about?
perpetuate illegalities.
No, electricity is used for perpetrating illegality.
My lord, he is doing that only from my
He is
premises.
reciting, you can't throw him out, but you wanted him to recite in a human manner. What the Supreme Court has said, Constitution bench, electricity.
Milord, he is not
It's
using the
is a facet of a right to life.
absolutely, Milord.
No?
Absolutely. But Milord, he is using this for some other purpose. Police,
Electricity.
Milord, without electricity, he could not have run this kind of
What,
business.
what are you talking about? So everything has to be disrupted.
Milord, I leave that to your lordship, but
Mr.
Milord, from
Banerjee,
my
those are your
premises, this is being
allegations.
done.
You have filed a suit for eviction that is subject to proof, and it's
Absolutely. Now, police has Milord submitted a charge sheet on that
if you can
allegation.
prove your allegations, you will be getting relief in that forum.
Milord, I'm afraid of the mob. Milord, I'm afraid of the local people.
For that, you have to take recourses to the.
So you have not come up with any kind of a.
I have not come.
Sir,
I have not come.
can you enlarge the scope of the writ? They have gone for a specific purpose. You wanted to enlarge the entire scope,
That,
which
that
is the horse, not journey.
Milord, I just placed Milord the
everything you will
facts.
do it.
Milord, I just placed the facts.
Why you inducted?
I
You did not,
didn't
you
know,
did not
Milord. I
know.
didn't know. I
You
didn't
did
know,
not
Milord,
know.
this is
At
going
the
to
time of
happen.
induction, you know only one thing. You were happy when you receive one thing.
That's true.
Now you are saying.
It is not possible for me, Milord, to know his demeanor, Milord, what he is up to, Milord. It's not possible for me.
That's
Now
why
that
I
Milord,
say,
this is
because
happening.
your mind was closed. You could not ascertain the antecedents of the person. Because you were.
Milord, seeing mob every time, Milord, outside my premises, it's not, Milord, a good experience I'm passing through.
Outside the premises. That's why that really struck my mind when you said. But now you have said no,
The
no.
photographs are inside, Milord. Mobs are coming, people are coming, they are shouting.
They're shouting.
Milord, once, Milord, they picked up his two-wheeler also. This is what is going on, Milord, at my place. Milord, I just wanted to place this before your lordship.
Where you live?
Milord, this is at Dokhin Barashat.
Where you live?
Bhawanipur,
Separate
Bhawanipur, Bhawanipur, Kolkata.
separate premises.
And
Don't
Dokhin
like-
Barasat.
Milord, I stay there. Milord, I have a home at Bhawanipur.
Investigation doesn't show.
You are.
Milord, I have just now taken instruction. Milord, possibly, Milord, when police
You
went.
have multiple properties, but at least in one property you stay.
Alert one POCSO case has been initiated.
Chile.
I have seen that.
Against whom?
Chile থাকে Bhawanipur.
I have seen the allegation as well. POCSO. And your police authority, without application of mind, and incorporated section 8. Your role is also doubtful. What you have stated relating to POCSO, it does not come under section 8. Inflicted section 8. Ah.
Where the father stay at Barashat, the son stays at Bhawanipur. Well, that's what Milord, my instructions, sir. Okay.
Other respondent.
বলেছে প্রেপারেটরি জজ থাকলে অর্ডার তো কোনো
কি বলছো বলো?
My lord has been fixed to take up the matter on 11th, my lord.
You have
This matter was-
directed this matter will be taken up on 11th.
Yes, my lord. It was mentioned before your lordship, my lord, on 4th of December.
The matter before your lordship, my lord, and your lordship, I pleaded the urgency, my lord, involved in this appeal, my lord. And accordingly, your lordship directed that the matter.
ডাইরেক্ট নয় বলেছে না
It was initially stated that on the 11th, this matter would be taken up. It was stated that
At the top
Can
of
you
the
not
list.
wait till 11th?
No, my lord.
11th of December. 11th of December.
ওয়েট করতে পারবে কিনা
Oh,
জিজ্ঞেস
11th,
করছি।
yes.
Is this matter on 11th?
Deeply obliged, my lord.
Going for it, all the councils uniformly submit that this matter was directed to taken note of. Yes.
My lord, only one thing, my lord, item number 6, my lord, kindly pardons me, my lord. My lord, it was passed over, my lord. My lord,
If nobody comes, then what? We are not
No, no.
supposed to wait. The others are waiting for their turn. If we have not, we have simply said, let it go out of list. That's
no,
all.
no, my lord was, pleased to, my lord, pass it over.
Pass it over, then we will come after that. Yes, next. After this heading is over, after 24. বারোটা থেকে একটা কল করে হ্যালো
Your Lordship, may I mention one original side matter which is already in the list, item 58. Your Lordship, the urgency is that we have received a communication. Department is giving effect to the order impugned in this appeal, Your Lordship. May I hand over the communication? Your Lordship, my learned friend on the other side is also here, Your Lordship. Your Lordship, they have kept the matter for hearing before the adjudicating authority on 10th. That is the urgency, Your Lordship.
He's on this.
Monday?
Gratefully.
Not only one
Why did it
difficulty.
is not taken up today?
Your Lordship.
On kindly text here on Tuesday, my lord. Monday I have some personal difficulty, my lord.
When do you want?
On Tuesday, my lord.
Tuesday, the date is fixed on Tuesday.
They can seek for an adjournment saying that the matter is pending before the honorable high court.
Don't oppose. Give a consent. Give a consent.
Very well.
Your Lordship, would kindly record, Your Lordship, or
What record? They are
Your
here.
Lordship. We'll make
They,
the submission.
if they oppose, come.
Grateful, Your Lordship.
Lord, may I be permitted to mention?
এটা বুধবার রাখি। On Wednesday it will appear. Wednesday.
Wednesday, very well. My lord, may I mention serial number? May I mention serial number 22, my lord? There's a defect in the cost title, my lord. It's wrongly appearing this matter, my lord. My lord, defect has not been cured. My lord, let me go out of the list, my lord. Serial number 22.
Let us see. Let us
My lord,
for the list.
Because I'm for the appellant.
I'm for respondent number 4, my lord.
Lord, here the name of the appellant is Mission of Mercy Hospital. And that is what I'm claiming also from your lordships today. My lord Justice Bhattacharya would be aware of this matter. Lord, there was a total. I'll tell you, lordship, why. Lord, there was a total due under the MSME award. 65 lakhs principal we've paid. This honorable division bench was kind enough to make 50 lakhs payment towards interest for final settlement. I was supposed to make 25 lakhs payment just towards the interest by the 4th of December. Look, I have absolutely no money. We are receiving notices from CESC also. I'm praying for 2 months extension of time to pay that 25 lakhs. I have no other submissions to make except the principal amount we paid. Please give us 2 months more time to deposit the 25 lakhs to them. This is just with regard to the interest. Principal we paid off completely. If your lordship looks at the last order of November 13th, and the financial penury hasn't really gone. It's a charitable hospital, my lord. I've had a word with the management myself. They're in a precarious situation. I'll have to close down the hospital. CSC's issued us a notice. 2 months time, your lordship will just show us some mercy. Give us 2 months to deposit that 25 lakhs. Principal has been paid off in court.
There is no order.
Fourth of 13th of November was the last order.
Prayer was made on
Same prayer. Same prayer. Lord, I had made the same prayer earlier also, hoping the situation will, this time your lordship will make it as a last chance. As a last chance gives us the 2 more months.
Banerjee, their prayer for interest was reduced.
Yes.
Thereafter, considering that
Your lordship reduced the prayer for interest because we
undertaken to pay that,
because we paid off the entire principal in court. We paid off 65 lakhs, seeing our bona
they're
fides.
entitled also to the interest.
Yes,
It's
yes.
not that they're not entitled to the interest.
Yes, yes, of course they're entitled
So
to.
now
But since that payment was
their
reduced,
claim was we have also reduced. We did not allow their
my lord, but that's still that
on
50.
condition that he will pay within this time.
Yes, my lord, but that 2 months extension your lordship will grant me. Otherwise, this will lead to a very, as a last chance gives us just 2 months. My lord, I am aware that I've had to take loan from the market to pay off that 65 lakhs at very high interest rates.
What is your submission?
Yeah.
My lord, I'm appearing for respondent number 4. My lord, am I audible?
Award holder.
Yes, your lord.
Award holder. My lord, the statutory interest rate has already been negotiated and it has been fixed as 50 lakhs. And after it was fixed at 50 lakhs, the first installment was to be paid before the ensuing puja vacation. They took time, and after that, they also took time, and it was revised that 25 lakh will be paid on 4th of December. Now they are appearing before your lordship and seeking 4 months' time, 2 months' time. My lord, it will become very difficult for me to be answerable to my client because they have come to a certain negotiation and that has been now stretched too far.
$20 lakhs you are supposed to pay by 4th of December, and the balance
25, my lord.
25.
25?
My lord, yes.
No, there was nothing with regard to the balance. At least that's what I'm told. I'll still check.
But in the order dated 4th of October, it has been recorded as 20 lakhs. Is it a typographical error?
No, no. That
My
is
lord,
correct.
on 4th.
13th September, your lordship will see the order. That is the real, that's the first order regarding settlement with regard to interest. Settlement was only with regard to the interest.
Yes, yes.
Principal 13th September 2024. MSME has agreed to accept a total sum of 50 lakhs as full and final settlement towards the interest and request that the entire money be paid before 30th of September 2024. The learned advocate opinion of the hospital submitted they are in deep financial trouble and they are unable to pay the entire sum before 30th. In order to come to a quietness to the matter and also taking note of the fact
30 lakhs is to be paid.
Accepting session director pays 20 lakhs by bank transfer by 30th of September 2024.
What is, have you paid 20 lakhs by?
This 20 lakhs again we took an extension. It came to December. That December again I'm asking for 2 months. I'm completely aware of where I stand, Vinod.
No, my lord, there was an order on 13th of November where 25 lakhs was directed.
From again I had come that day. You could recall I had come and then I made the same prayer. I'm again constrained. This time as a last chance gives us 2 months. If I can pay, I'll pay. Otherwise,
the amount was fixed, considering that you will be paying within this time.
I'll be paying 20 lakhs by 30th of September. Yes.
The entire amount that you will be paying by phases. And the first payment will be made by
30th of September.
30th of September. You have not done.
I have not paid.
So now,
from September, all I'm saying is today we're in December. So September payment of 20 lakhs, I'll make by February. That's my own, in effect, that's my only prayer.
That will be again, they will be entitled to some
Gives me a month
of energy.
Gives me a month.
2 months and
no, give me 1 more month from today.
30 lakhs is will have to be paid over and above that 20 lakhs.
Later on, after that.
Yes. So first amount you have still not now paid.
Not paid. But I have received notices from electricity department also saying 51 lakhs
that is a different thing.
Just to highlight that I don't lack bona fides. I came before the court and paid off the principal. In fact,
What is the magnanimity of this word bona fide?
No, at least that the prayer. No, please.
Sir, let us understand the conduct would show that you were given some kind of a.
Your lordships have
I
been
would
very
say
lenient.
out of way. They have gone and then they settled it. Had it been that you have deposited 20 lakhs and then you want a further payment of the rest amount by some we can understand. You have not shown
Not so much out of way also. I'll
shown
tell
the
you,
color
Lordship,
of
why.
money, even a 1 rupee till now, and then you say bona
No,
fide.
no, Milord, I have paid off the entire principal. The
Sir, this is
MSME
not-
rate
Sir, this
was
is
at
not the case.
MSME
You
rate
have
is at-
paid the principal. Then what for? There is no interest to be
no,
charged.
no interest, which is why Milord, the MSME rate was at 18% per month. That, of course, that is what weighed before the Honorable Division Bench and reduced that to 10% per annum and made that 50 lakhs.
My lord, with deepest of respect and sincerity, I submit that a statutory right cannot be curtailed because it was so represented. Our client came down to 50 lakhs.
Mr. Pandit, just 1 minute. This is as much as I also could have done as your lordship's officer. This is the situation my client is in. This has no real law involved. I am not in a position to pay. Your lordships are aware that in that day they accepted this money because they also know if they take me to execution, they'll not get any payment. My situation is such, what will happen? The award will roll into execution, they'll not get anything out. So at least they got the principal, they're getting some interest.
To take steps whether they will get anything in execution or not.
Correct, but which is why they also in principle agreed to the principal sum. This is where I am.
So they could have foregone the interest part. They did not.
They did not.
So
18% per month.
Let them execute whatever they can realize, they will realize, and whatever that's
No,
under the
before
law.
your lordship's
permissible,
hold that
let
the
them do.
settlement has failed, gives us one more time to make the payment.
Not thrice you were given time.
Twice, I think. No, not twice. Once before.
Sorry.
September, it was I was to pay once before.
November করলো, November থেকে December করলো.
Once. This is the second time I've come seeking for extension.
Twice, my lord. This is a thrice. This is the third time.
Order.
November 13th order. November 13th order shows that from 20 lakh, Honorable Chief Justice was
on.
He's right. He's right. 13 to 4th, 4th to this. This is the third time I've come. He's right.
I have read the other amount, 30 lakhs is still to be paid. You have not even paid the first installment.
Gives us
or any portion of
1 month, my lord. I'm just hoping they'll be a little reasonable and give us the 1 month. If we can pay, we'll come again. We'll otherwise come back.
My lord, one humble indulgence that on 4th it was directed to be paid 25 lakhs.
The Pandit with
as per the
court.
So it will not be 30 lakhs.
This is a high time.
By tomorrow.
ডাকো মক্কেলটা কোথায়? কেন পাকা মক্কেল 3-4 বার একদিন আইন কিছু নেই, রোজ এসে হাত জোর করে ক্ষমা চেয়ে
Also not getting. Because if they are going to pay in January something. They are not working. They stop their work.
This week.
Stop.
1 month.
They have taken.
But this is not a matter where I can actually haggle. I 1 week I'll not be able to come up with.
The discussion has got.
Huh? No, that I don't know. I was lip reading. I was trying to lip read.
That's the problem with the online.
No, I couldn't hear. I was actually.
Communication amongst between us is also going.
No, nothing could be heard. I can't hear anything. If anything he can hear, I'll not be able to hear.
From lip reading. From lip reading.
From lip reading. Just lip reading. 20 years of experience, something I've also learned.
You can give you a time of 1 week. You have to pay that 20 lakhs.
I'll not be able to pay in that 1 week time.
Better then we'll record it and then we'll.
No, then it gives that 1 week. My instructions were to seek some extension. No, please, the client is not here today. Please don't record it in 1 more week. Gives us that 1 week, keeps it after a week, we'll come back. If I haven't paid, I haven't paid. 5 more days I'll get. That 1 week what has fallen from this honorable court, let that be there. Otherwise, it will be difficult for me. That 1 week it's come, I have said I'll not be able to pay. Keeps it next week. If I can pay, I'll pay. Otherwise, I can't pay. Then whatever will happen, will happen.
The Banerjee learned advocate appearing for the appellant prays for extension of time to pay the amount as directed by the order dated September 13, 2024 and now he further submits he prays for 2 months time to pay the amount of rupees 20 lakhs as directed to be paid by the order dated September 13, 2024. The prayer for extension of time to make such payment is seriously opposed by
আমার তো বলার ছিল।
hospital was directed to pay a sum of rupees 20 lakhs.
No, but not like Mr. Anirban. This is
by
the camera.
September 30, 2024. On 4th of October 2024, the time to make such payment was further extended till November 13, 2024. So, the appellant did not pay the said amount within the extended time, and by an order dated November 13, 2024, the appellant was directed to pay to pay a sum of rupees 25 lakhs on or before December 4, 2024. Today, the prayer for extension has been made by the appellant. Considering the fact that the time to make payment has been extended from time to time, and the appellant has not shown their bona fide by paying either the said amount or any portion thereof, we were of the opinion that further time should not be extended. However, we take a slightly lenient view, and in order to give another opportunity to the appellant to pay the sum of rupees 25 lakhs, we direct this matter to be listed on next Friday. Direct this matter to be listed on December 13, 2024. So the appellant shall pay the sum of rupees 25 lakhs as directed by the order dated November 13, 2024 on or before that date on 12th of December on or before 12th of December 2024. It is however made clear that there shall be no further extension of time to make such payment. Is this matter to the
Great.
Better to exhaust money on a litigation
Then?
than to pay.
No payment, even either way. In fact, when he was writing the name down, I told him, what is the point? It's not like that's going to help us. But I know the condition of this hospital, so anyways, we'll try and come back next.
They are also MSME, Mr. Banerjee. We have to also
But
consider
MSME
that.
with an unimaginable market, making amounts, we have their balance sheet. But anyways, there is an award. What is there is there. What is there is there.
They're entitled to that amount.
My challenge to the award also failed because I could not deposit the money. If I show your lordship the award, on the face of it should go. But now section 19 requires.
You cannot go into that.
You cannot, of course. But section 19 requires I have to deposit 75%. I didn't have the money. I couldn't file, couldn't carry on. It got dismissed for default.
Yes.
Great.
Oblige.
I, for the appellant in this matter, my lord, there is a delay of 111 days. On the last occasion, there was a direction to serve the other side, my lord. So we made an attempt, but it has, the department couldn't mail the SSC that the matter, because there was a last order. May I have a, it was given to them, but the department couldn't, because maybe for the time bearing assessments, they are a little busy. So let this matter be posted in the month of January. In the meantime, we'll take the exercise of serving them again. Four and five, it pertains to the same SSC. There is a delay of 203 days. Only the assessment years are different, my lord.
Service?
Yes, service has been affected, my lord. The delay. Guturita 203 days আছে
The item was delivered only on 29th of November.
Yes, my lord.
We are keeping it in the next week.
Next week, my lord.
Too short a period of time to engage a lawyer and then
Yes, my lord.
let them get an opportunity to.
In both the matters, my lord.
Both the matters. It appears from the affidavit of service that
Second one.
Yes, file in both.
affidavit
So
service
the
filed in court
affidavits-
today. Affidavit service filed in court today is taken on.
If you.
Six. Lord, in this Lord, there is a delay of 13 days.
Have you served?
Lord, I have sent, but possibly it has not been
Attempted, but not successful.
not successful. Not successful, my lord. Keep it, my lord, next week, my lord.
The counsel for the appellant submits that the service could not be complete.
I am appearing for the appellant, my lord.
Yes.
My lord, we have served, my lord, on 21st November. My appeal has been served upon the respondent, my lord. This is the affidavit of service, my lord. There is a delay, my lord, of 67 days, my lord, in preferring the appeal, my lord.
For 1,76,000, you are filing an appeal.
My lord, the issue is, my lord, Rule 83A of the Central Excise Rules. And that issue is pertains to the, my lord, constitutional validity. Now, as per, my lord, litigation policy, if there is any constitutional provisions under challenge, then irrespective of the monetary limit, department can prefer the appeal, my lord.
But the constitutional validity has not been
My lord,
before the appellate forum.
my lord, the learned tribunal, my lord, relied upon the decisions of Insure Global, my lord. That issue was pending before the Honorable Supreme Court. And but if your lordship, the issue is Rule 83A, my lord. He is violated.
They are not vested with the power to decide the virus of the act.
No, my lord.
So
My lord, now that issue seems be pending before the Supreme Court, my lord.
you have preferred an appeal.
My lord, this is our instruction, my lord. And there are এটা already Supreme Court decide হয়ে গেছে। And some matters has been admitted in this regard, my lord, before this honorable court, my lord.
Well, similar issues have been admitted because since the
I am not saying that it is not. I was just surprised that the department for a paltry sum of rupees 1,76,000 is preferring an appeal. Now, under the income tax, there has been no policy decision that
over
up to
here
certain amount they will not prefer an appeal.
over here also.
Here also, my lord, 2 crores, my lord.
Here also definitely the same policy.
Yes, my lord, same policy.
That's called a litigation policy.
Yes, my lord. My lord, similar issue is involved. There is also delay of 67 days, my lord. I have served. This is the affidavit service, my lord.
When the service is effective,
My lord, 21st November 2024.
Same order.
Grateful, my lord.
Same order.
separately.
Affidavit of service taken on record.
Delay is 67.
67 days.
ওটা আগে ছিল 63
না, 7.
67 same.
আসুন স্যার। Nine.
My lord, over here, my lord, the service was attempted, but my learned friend is appearing. He has informed that he will take service. So we will serve the copies because the service returned with the with the endorsement left.
And there is a change of address,
Good
man.
service in eye of law. Serve him here and now.
So we will open the envelope
But,
and give the copy.
we are keeping this matter on next Wednesday.
My lord, kindly in the month of January.
January.
At least 2 weeks, my lord, I am receiving now, my lord, petition.
Sir, take it, you are getting 1 week time. Next Friday the
Next Friday.
Come on that. So,
It is-
it is submitted by the council for the applicant that the service.
Mr. Banerjee, you are serving him the memorandum stay.
Memo and the stay application.
Applications as well as memorandum of opinion.
এই স্টেটা ছিল না, স্টেটা দিয়ে দিবেন। বাইরে গিয়ে দেখেন।
Yes, call the next.
Hello, 10, I am appearing for Allahabad Bank. Respondent SSC copy has not been served. My lord.
You're still alive.
It has been merged with Indian Bank.
What I asked.
Yes.
Are you still alive?
Yes, my lord.
Your existence gone.
But they have to change the cost title, whatever they are filing. It is.
What is the concept of a merger? The moment the company
No,
merged.
it is not applicable. It is not applicable by the Reserve Bank of India in the case of banks. So far I heard from the income tax matter, my lord. I am not sure.
Heard.
From the bank, concerned bank. Anyway, lordship kindly direct.
Yes, the cost title.
My lord, I will do it, my lord.
Because they have merged with the, I think the two banks.
Yes.
Indian and.
Allahabad Bank. Indian Bank. Allahabad Bank has been merged with Indian Bank.
Full.
Full.
I think some ports, some.
No, my lord. I have done 5, 6 income tax matter. My lord, it has been merged totally.
Cost title you see.
My lord, I will do.
Leave is granted to the appellant to
11, my lord, I am for the appellant.
160.
You know, this is an appeal under section 35G of the Central Excise Act. You know, there is a section 5 application, my lord, that I have served.
How many days delay?
You know, there is a delay of 163 days according to the department, but according to me, it should be 103 days. Because, my lord, we had wrongly filed the writ petition challenging the order of the tribunal. So, my lord, that period should be exempt.
Only thing is the
14 section 14 would apply to us, my lord.
that does not really wipe out
No,
the
not
delay.
delay. 103 delays, my lord. 103 days delays.
Be the same. Only thing is you will get a benefit of.
Benefit. This is the affidavit.
Yes, what do you say about delay?
I think,
Just have to leave it to lordship.
well, I leave upon your lordship, my lord. If your lordship wants to condone the delay may be condoned, my lord. We'll put the matter for admission, my lord, then. In the
You can keep it on my next Wednesday.
Lordship will condone the delay. Lordship will condone the delay, my lord.
Obviously, otherwise the appeal is not regularized.
There is a delay of one.
Lord.
Friday,
Or Friday.
When both of you want, Wednesday or Friday?
Well, Friday.
Friday would be better, my lord.
Friday.
I'm grateful to lordship.
My brother is more diplomatic. The ball in your court. Suggest a date.
Grateful, my lord.
Item number 12, the service has not been affected by my. Well, kindly give me. Well, give us 2 weeks time.
Service is not complete. Let the matter be adjourned for 2.
Lord, sir, service has been completed, my lord. There is a delay of
3 days. How much days, sir?
yes, my lord.
Don't look at their note.
Yes, yes. It has been served.
It has been served
Delay of 3 days.
3 days.
Because the main application, the appeal is with regard to delay of some 2200 days before the tribe.
Oh, then further delay here.
Delay here is 3 days.
No, no.
That order, yes.
That a further delay here.
Is 3 days.
That is why I say further delay here. That delay is enormous. Again, a further delay. I do not know. I have been out of touch in this branch of law for a pretty long time. There is a cap that's up to that level, the delay can be condoned by the appellate authority or tribunal.
My lord, this has gone wide beyond. This is
So that is,
2200.
my lord, that is beyond before the commissioner. Its time period has been fixed.
Yes.
Thereafter, after extended period, up to some period has also been fixed.
And the tribunal, enormous,
Tribunal can control.
Cannot.
unlimited.
Unlimited.
Cool.
What else? You noted.
মেমো পিছনে একদম শুরুতে দিন
হ্যাঁ
Yeah.
Yeah.
Grateful.
Well, it wait for the response.
चलो ब्लॉट ये चट्टी में
ডিলে নেই
ডিলে আছে
না না ডিলে নেই ওই তো কোশ্চেন অফ কি ফ্রেম করেছে
Malad, I have
7 days.
Malad, I have tried to frame 3 substantial questions of law.
There is a delay.
Delay of 7 days, Malad, yes.
So unless that is condoned,
yes
if we reject, then what will happen? No appeal.
ডিলেই পাইনি আমরা স্যার
No. Keep it with you.
Hey,
File. File it on the next page.
yes condonation ফাইল করেছিস oh
There is application for the condonation.
not
Malad,
here
it is here only. It is in this application only.
Oh, I do
of
not
my
find.
Yes. Kindly take the prayer. Prayer A.
Oh, composite application.
composite
But since it is original sin, Malad,
Composite.
but Malads are entitled to.
because the stay application will become infructuous
ডিলে ডিসপোজটা হয়ে গেলে কি হবে
আগের তো কিছু লোককে জানা আলাদা
composite কোথায় সে তো সবই হয়
আরে পৃথিবীর কিছু গাছ তো বাঁচাও একটা পেপার তো কম লাগে
This is the application for condonation of delay of 3 days in
We are not. Well, I have no problem on it.
Please suggest
Wednesday. Whatever my learned seniors.
Wednesday করে দাও।
Well, we are honoring the early. But instead of Wednesday, but either
Friday.
Monday or next week.
Friday. He will be going outside for. Yeah.
He knows that is why he is suggesting that.
No, that's why I was.
Either this next Monday or Monday week.
Monday week.
Monday week is not.
No original
I think
site.
normally they do not take up this
Budhwar,
tax
Shukrawar.
revenue matter.
Budhwar, Shukrawar.
Wednesday.
So it is only Wednesday and Friday.
Friday.
So suggest any day.
But Wednesday. Let it keep it on Wednesday. 11 তারিখ তো?
Wednesday is
11th.
11th.
Both matters.
পাগল করে মারবি তো রে ভাই।
14 and 15.
But 14 and 15 are same.
Composite application.
Same application, same delay.
Period of deal.
Same with us. And as out of common order.
Same. Replay.
This is my epic melod.
report দেখাচ্ছি।
We have, my lord, sent them a copy of the application, but that was returned, my lord, with the remark, my lord, insufficient address, my lord.
Insufficient address.
But my lord, as per the order of the tribunal, my lord, we have given the full address given there.
They have filed an appeal before the tribunal. They
Yes, my
filed.
lord. Yes,
The address which they gave in their
appeal.
is the same.
Yes. Lord, kindly takes up the memo appeal. The address of the, my lord, kindly takes up, my lord, the memorandum appeal, my lord. There, my lord, the order impugned has been annexed, my lord.
Can you not serve upon the learned advocate who appeared
before
for
the
them
tribunal.
before the tribunal?
Lord, kindly leave may be given, my lord, so that we can serve it, my lord. Miss, my lord, Srimati
I
Shweta
think
Mukherjee
she
was-
appears,
Yes,
she appears
my lord, my
before
lord,
this court
my lord,
also.
my lord.
Who?
Shweta Mukherjee. Shweta Mukherjee.
Okay. The counsel for the appellant submits that the service was attempted upon the respondent, but the postal article returned with a remark within court school insufficient address. It is submitted that the service was attempted on the address given ছেড়ে পড়ে
This is my appeal, my lord. I have already served the other side. May I file the affidavit service? A delay of 707 days, my lord.
Lordship, I am praying for not today on behalf of.
Why, madam?
I am praying for not today.
Why?
Because my learned senior counsel is engaging to another court, affiliate court.
Mr. Duggar.
Mr.
Mr.
Anil
Duggar.
Kumar.
Mr. Anil Duggar.
Anil
He is
Kumar
appearing on
Duggar.
behalf of the SSC, my lord.
Senior counsel.
So not senior counsel, and
My
such,
senior-
not designated senior counsel, but it's senior.
Senior advocates panel.
Senior.
Or what?
No.
Is this delay?
There's a delay of 707 days, my lord.
Madam, can we direct the affidavits to be exchanged?
I don't know about any.
Because the delay is enormous.
Not, my lord, there is delay 707 days.
Yes. Oh, he's not objecting to this delay.
The delay is enormous.
Yes,
madam.
my lord.
They
So
must
they
get
can file an affidavit. They can
they
file an
must get
affidavit.
opportunity to deal
Yes.
with the government. But she's not understanding what we want.
Yes, that's what I am saying. I explained it to her, but she couldn't follow it.
The period is over.
Ah,
I'm appearing in this matter, my lord. But
I'm praying for not today.
but there's a
On the-
there's a delay of 489 days, my lord. Similar pray maybe.
opposition.
Yes, yes.
Give your name on the.
Yes, yes.
Okay, that's it.
Not Mr. Tucker's name. Your name.
My lord, I'm appearing on behalf of the appellant in this matter, my lord. We have already filed the affidavit of service, but as per my lord's last order, we were directed to serve upon the other side's advocate. We've done so.
Now you have received instruction to appear.
Yes.
My lord, there's a delay of 6 days.
6 days.
Six.
Only 6.
Or
Only
single
six.
six?
Only
No,
6.
Single digit.
Single digit 6, my lord.
Hey.
I have for the respondents.
But it will take time, my lord.
You have enough time.
My lord.
What is this application?
My lord, this is a my lord the mandamus appeal.
No, there is no application.
This is a my lord stay application.
Yeah.
Appeal within time.
Within time.
Within time.
What is the nature of the order and why you wanted a stay of the operation?
My lord, the estate officer passed an order in the year of 2006.
State?
Estate officer under the PP Act.
Urban Land Ceiling Act.
No, public premises.
Public premises passed an order in the year of 2000.
Yes, section 5. Eviction order of 2006.
Appeal under section 9?
Not done.
Not done. Straight away before this court.
No, after few years, 18 years, he's trying to challenge by way of a writ petition. When now the damage proceeding has started, now this writ petition is filed.
We are not challenging section 5 order.
Now by way of the writ petition which has been dismissed.
Let him complete.
There is an appeal.
No, I just answered through a query. I never hijack anybody's case.
Statutory provision for an appeal.
Lord, I'm coming. I'm coming.
Then why there is no delay? I do not know.
Lord, let me complete, my lord. Because, my lord, the questions which has been put to me, my lord. My lord, the order dated 27th of March 2006. Order dated 27th of March 2006 passed by the estate officer has been communicated in the year of 2023. It is evident from the pleading itself. And, my lord, if I place the impugned order before your lordship, my lord, it would be evident that there are certain mistakes and there are, my lord, certain wrong observation which is contrary to the record. My lord, this matter was taken up, my lord. Impugned order was passed on 3rd of October 2024. The Honorable Single Bench, while considering, my lord, this writ petition, did not consider certain aspects. And, my lord, therefore, my lord, the Honorable Single Bench did not apply his mind at the time of the, my lord, the adjudicating the, my lord, the writ petition. So the issues were.
Sir, if there is a communication after a gap of, say, more than a decade, then the limitation under the Public Premises and Eviction of Unauthorized Act starts from the date when the order is served upon you. You could have preferred an appeal.
Till today, I did not get any certified copy of the order despite making my application.
Not necessary. They have to communicate the order on that basis.
My lord, the principle is this. There is a period of the, my lord, the 12 days.
Communication.
No, my lord, yes, my lord.
Just over.
You were supposed to assist me. Better than give me one.
No, Dr. Vaida. No. Before the district judge. Before the district judge, back around the court position. The EC order to give. Order to copy. Don't worry, die now.
Lordship, this is the act. PP Act. I'm sorry, my lord, I only have one copy.
Then give one copy. No difficulty. Yeah?
PP Act only. Copy. Oh, fantastic. Fantastic.
12 days is there.
বের করো 9 বের করো সেকশন 9টা বের করো
It is under my application. Providing the
Section 7 তো দাঁড়িয়েছিল তো। কোন পেজে সেকশন 7 এ দাঁড়িয়েছিল?
Now kindly see below 9(2)(b). From the date of the communication of the order. Till today, order has not been communicated. Only subsequent proceeding has been communicated to me. Then I approach before the authority. Give me the document. All the documents has not been given. Only the inspection has been given. On the basis of
Come tomorrow, let us see.
How could you challenge that order in the reach?
That is
You
the
are
thing.
not communicating
Well,
with that order.
after eviction, when damage proceeding was initiated, he was there. He had constructive knowledge of the eviction order pass.
He has been evicted or not?
He is long time.
Milord, my case
Now,
is
well,
in the
it's
year
an
of
overt action
1980.
to resist the damage which is going to be imposed.
He's not in possession now.
No.
Long back I have surrendered 1983.
That is the dispute.
Milord, if every time he interject, Milord.
Come tomorrow.
order 41 and a connected application of the current year.
Lord,
For
application
inclusion.
in connection with first. Application in connection with first appeal.
41.
My lord, 2013 appeal.
Inclusion for my lord passing appropriate orders, my lord. Inclusion,
with what?
my lord, in connection with first appeal, my lord, disposed on 5 September. My lord, during the pendency, my lord,
Here.
by 2024, my lord. My lord, decree, my
We
lord.
have a determination. We have first appeal up to 2015.
Grateful.
Sir, I am 78 years old and I am pleading my case. Just now I had an attack. I am a patient of terminal illness. I would request you to give an early date for hearing.
For what? Which matter?
Civil matter, FA.
FAT of which year?
This is already in the list.
At item number?
Last, absolutely last.
Which year?
2007.
2007. Do you have any lawyer?
No, sir, I will plead myself.
Okay. Who is appearing for the other side?
SK Sadhu and Company.
SK?
Sadhu and Company.
Can you give a notice and come on Monday?
I can give a notice now.
You can give a notice that you will be mentioning on Monday. In their presence, we will fix the matter one day.
Can I have the hearing on Monday? I can give the notice now.
Not hearing, they may not be aware. So you come on Monday, we will fix in their presence a day. On that day, we'll
Just
take
now
up.
I felt sick. This is the medical.
No difficulty. We appreciate. You please give him a notice, let him come, we'll do it.
Monday.
Monday.
Whether I will give them notice, whether they come or
2
not.
p.m. 2 p.m. No. You just, if they do not appear, we'll see to it.
2 p.m. Thank you, sir.
Mention at 2 p.m.
Thank you, sir.
My lord, may I have my lord's kind leave to file an appeal without a certified copy, my lord? My lord,
The order was passed.
my lord, it was passed on 28th of November, 2024, my lord.
Have you applied?
My lord, I have applied already, my lord.
Have a copy?
My lord, I have already annexed, my lord.
Have a copy also of the order?
My lord, yes.
Yes.
My lord, there are 2 more matters, my lord, which are passed on the same date, and I have already annexed, my lord.
Have a
Thank you.
copy and application both to be
My lord.
annexed with the memo.
I have already done that, my lord. I'm grateful, my lord.
Lordship, in item number 2, Mr. Gotakurata is appearing for the private respondent, Lordship. He is leading me. Lordship, we will file our written notes of argument in a while, Lordship.
What?
Written notes of argument, Lordship. We will file it
There
by
was a
course of the
direction
day,
for
Lordship.
filing of the written notes of argument. Why you are not filing it?
Lordship, we will file in a while, Lordship. It is
In a while.
in few minutes, Lordship.
Oh, few minutes.
Few minutes, Lordship. Few minutes, Lordship.
Yes. No difficulty. Subsistence allowance. That matter?
Yes, my lord. Yes, yes.
Supreme Court judgment that was placed in 2001, which says the deemed duty. Instead of on duty, language in the law is on duty. Supreme Court has taken it to be deemed duty in respect of an industrial settlement. Lord, I have, if your lordships kindly come to page 14. 13 থেকে ওনাদের কেসগুলো আমরা if your lordships kindly come to page 13.
এদিকে আসুন না প্রসাদ দা আমি ব্রিফটা পাঠ করি
And down to II at the bottom of page 13. 2001 volume 2 SCC 519. This was the judgment relied on by my reference. Placing reliance on tag of 10 and 11, it has been argued on behalf of the respondent organization that the concept of basic wage cannot be considered in a conservative manner, and contributions are required to be made on the emolument, even if the employee concerned was not an. In terms of the said judgment, it is not necessary that the workman must actually be on duty, or that the workman should actually have worked in order to enter the positions of the actor. And the example of declaration of lockout by the employer has been relied on. These are replied. It is well settled by the autonomous court. In the case referred to 2009 the court did not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Circumstantial flexibility. One additional or different fact may make a world of difference between the constitution set two cases. Therefore, disposal of cases by blind reliance on a decision is not proper. This judgment of 2009 I have included. And keeping in view this golden principle and aforesaid, if we take a turn to the facts involved in the judgment cited and the case at hand, clearly evident that the cited judgment can never be regarded as precedent. In answering to the point of question, as to whether subsistence allowance come within the purview of basic wages or not. The basic differences are to the following event. Judgment cited is 2001 and our case. The distinguishing feature. Judgment cited the apparent company as a whole. Fifth with operation from 1984. The industrial related to various claims for area wages, etc. The Labour Court passed award. The Labour Court passed award passed in their favor. Possession of operation was found illegal and has not dissented the workman to receive area wages, etc. Their non-payment of salary was universal in nature. But your lordship will kindly remember this. The Supreme Court says that basic wage must be something which is payable universally. Now, in the case at hand, coming back to page 14 again, right hand side. In the present case, the original private respondent field sitting, along with other workmen, were placed under suspension, pending deduction of $100 was paid to them. This had no universal or general application to the other employees. The workmen and union got favorable orders from the learned Labour Court in their favor for the payment to which they were entitled to. They were backwards. The industrial settlement was found to be and industrial stoppage of that was found to be illegal. Suspension was found to be illegal. That was in the spirit of the entire order. That was found to be illegal, and the court directed that. Now, here in our case, the learned tribunal said that the appellant is justified. Appellant is fearlessly. Is justified in taking the original private respondent along with other employees under suspension. Suspension was upheld. Then C. In connection with cessation of duty, right to wages is accrued if it is held to be illegal. While placing an employee under suspension, right to different employee as per period of suspension never arises, and is entitled to subsistence allowance only. B. Cessation of functioning factory postulates severance of employer-employee relationship. During the period of suspension, the relationship never gets set. Then E. In the event cessation of the work or place of work is held to be illegal, the resultant effect is the employee concerned shall be deemed to be on duty. That is what the Supreme Court said in the facts of that. Then, in our case, in case of suspension, the person concerned is restricted from attending his duties, and such action on the part of the employer has been held to be valid. So he shall not be on duty or on duty. Then F. In the cited judgment, the award passed in favor of the workmen and the union created a positive right for arrear wages and retracement compensation. Right hand side, since the learned tribunal held that the management was justified in placing the workmen under suspension, no positive right acted in their favor. Then G. The management entered into a settlement with the union on such and such date whereby it was agreed by and between the parties that the management shall pay a sum of ₹1,10,000 for the period mentioned there, even though the payable amount was ₹1,23,000, etc. On the following counts: total wages, remaining wages, gratuity, statement published. Is of 1 crore 10. The right hand side, the appellant never paid anything on account of total wages. Since before imposition of punishment, the original private respondent reached the age of superannuation. As per the settled position of loss, you have paid the remaining portion of the wages which was deducted while paying subsistence allowance. Then H. The term of the settlement which provides that there shall be no deduction from the amount paid signifies that the management agreed to take upon the liability. And note, there was the settlement provided that there shall be no deduction from the amount paid. No deduction on account paid. That's a settlement. The statute never cast any liability upon the appellant management to deduct the contribution from subsistence allowance. In fact, the management acted bona fide in giving both employer and employee share of the PF to the employee concerned at the time of the return. Act doesn't require it. We did it on our own. On the contrary, the Act will not give time because paragraph 32(1) that says on the current salary. That's the right. Then I, the attention of the court was not brought. Paragraph 32(1) of the EPSC scheme in the reported judgment, which requires contribution to deduction from current rates. Now, this 1991 CSC 119 had occasion to consider paragraph 31 of the EPSC scheme at cited this. As my lord Supreme Court specifically pointed out, by following 31, the employer has only liability being to deduct wages for the current period only. It should not be out of place to mention that the Honorable Court, while delivering the judgment in the case which relied on by the respondent provisions, did not take into account the earlier judgment reported in 1991-3 by a bench of equal strength. Secondly, the attention of the court was not drawn to paragraph 31 of the PSC scheme. Now, which will be the binding? 91 or 2000? Paragraph 5.1, binding precedent. It has already come to light that the Honorable Apex Court, while delivering judgment as would appear from the cited decision, that the Honorable Court has not taken into consideration the earlier decision of equal strength. In such a situation, the earlier judgment has to be followed by the courts in the country as a binding precedent. The relevant citation in this regard as follows. 2004 Volume 1 SCC. Copy of the judgment I have annexed. The court here in the judgment has laid down that when the subsequent judgment does not consider an earlier decision and does not use any reason for deviation, then the earlier judgment will be law binding under Article 140 and not deleted. There, the Supreme Court said that we had taken different view at different times, but this is the thing. Now, 5.2 decision of a full bench of the Honorable High Court Calcutta to Assembly. Then conclusion. On a consideration of the facts and circumstances involved in the present case, as well as the law of the land as indicated herein above, it is respectfully stated that the subsistence allowance can never come within the purview of basic wages as defined under Section 2B of the said Act of 1952. It is well settled that that has to be interpreted keeping in mind a statutory provision, even in a social welfare legislation, the literal meaning thereof, especially when it is explicit therefrom. Reference may be made to the case reported in 2011, Volume 4, SCC. Reference to one a few portion of the judgment that I beg to rely upon on this
Annexed.
Annex T, starting at page
74.
74. No, 74, no, 76.
76.
Page 76, it starts from
Act 78.
Kindly come to page 78.
The court says, এটা নেই তারপর উঠে যাবো এটা তো
Yes.
court.
Kindly come to page 78, paragraph 5. Courts should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observations of courts are neither to be read as Euclid's theory, nor as provisions of the statute, and that too taken out of their context. These observations must be read in the context in which they appear to have been stated. Judgments of courts are not to be constituted as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark in lengthy discussions. But the discussion is meant to explain, not define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes, the words are not to be interpreted as statutes. In London, then I take kindly take page 89.
Starts.
Page 89. I refer to the relevant paragraph at page 89.
Starts with 80.
4 volume. It starts at page 82. I am
No.
80. Starts at page 82. Kindly straightway come to page 89, paragraph 18. Furthermore, this court by rendering judgment in Dhandiram Katova Kadam was bound by its earlier decision of a coordinating in Ramchandra Desabati. We are bound to follow the earlier judgment, which is precisely on the point in reference to the later judgment, which has been rendered without adequate argument at the bar, and also without reference to the mandatory of the act. Without adequate argument at the bar, and the subsequent part without reference to mandatory provisions are both in this case, have not been considered. All it is considered in 91 we had cited.
These are three judges.
What is the law on this subject after 2004?
Law on the subject matter remains the same. that are not the later judge, not the later judge.
With departure. That's why I'm asking.
The later judgment.
No.
The earlier judgment will always prevail because the Supreme Court says, yeah, had I been making an argument before the Honorable Supreme Court, I would have said that later judgment is for impugn. I cannot argue that before your Lord. But I can argue this, that when an earlier judgment, considering the relevant statutory provisions, is there, a bench of co-equal respect in a later judgment cannot take a different, particularly without having notice of the relevant statute, as has been done in this 2001 judgment, without following the 1991 judgment that we have. And this is a three judgments. 2004 is a three judgment.
5 judgments.
Holding what in the right? Possible judgment.
Community of Daudi Bora.
করতে পারবে তোমার কাছে এটা আছে ওই যে ট্যাবটা
Community of Daudi Bora.
Community of Daudi Bora. Is it on what the privilege or precedent means?
That Constitution means.
5 judgments.
I believe.
Gotcha. Gotcha. Sorry, Borota, you are
You're doubting, Mr. Gupta, that it is there or not?
No. I have asked him to find it out. Find it out so that I can go to it and give my reaction.
Have you found out?
Yes, he has been able to find it out.
2005? Or letter?
Then 5.
Which year?
2005. 2005, volume 2, SSD, 6, 7.
5 judgments.
Yes. Justice Lahori, Exaction, Gujarat Party, Balakrishnan, Indian, and the
2005. 2005.
So this is more binding on us, by judge.
Yes.
Some portion will support you.
This 2005 judgment, I now recall, I have read it. This judgment says in situation, at present the court is bound by, and where it can differ or where it can refer to a London. There are the 3 situations. Now, where it says that bench of co-equal shall not from an earlier judgment.
The proper course is to refer.
Yes.
But there is one.
It differs in that
There is 1 or 2, 3 lines. That will go there. Six. SCR. What is the cost at?
1054.
Central Board of Daudi. Central Board of Daudi. Officers will have the
2005 2 SCC.
2005 2 SCC. 2005 Central Board of Daudi.
I had the community of Daudi.
Central Board of Daudi Bora community versus state of Maharashtra. I had cited this judgment on I don't remember the constant, but I have cited judgment not in support of the same proposition that a bench of co-equal strength cannot differ. If
No.
it wants to differ, it has to differ.
That's why he says, to some extent it will.
Yes.
Strengthen your case.
But otherwise, I do not remember any portion of the judgment which will go against me. I just
I think 3-4 lines are there somewhere. Anyhow, we'll consider it. Don't worry. Consider this judgment as
well. Kindly make a note of this file. On the first page of the note I have submitted. This 2005, follow? I will.
So you are citing a judgment on this. That is, you are citing a Babu Prush. You are citing 2004 volume 1 SSC 681. Here I am writing 2005 volume 2 SCC 6
7
3.
Okay, last judgment.
Subsequent judgment of Justice Sinha in 2007 also.
But possibly, my lord, from the principle, this principle, no judgment has deviated,
Actually,
to my knowledge.
There were 3 principles that was operating. The first principle is 2004, which really originates from a Privy Council's view. It says that if an earlier decision of a co-equal strength judgment is unnoticed or a notice in a subsequent decision bench unnoticed, then it is an earlier bench decision that would prevail.
Yes.
That's very simple. There was another view which was infused in between was that if that earlier bench decision was considered in a latter bench and distinguished on facts, then it will not be treated that it will prevail over the latter bench because the latter bench has described. Third view, apropos the second view, was adopted by our High Court, Justice A.M. Judge. They say that if in the such situation, then if you find
it is open to the
close proximity of the facts of either of the judgment, then in that event you can follow either of them.
Now, if we go, if we look to this matter by the third standard, that proximity of fact. Now, here, my lord, I have distinguished that, my lord, in 2 columns. I have distinguished.
That I understand. So that was a third view which was taken. And
there is a judgment of Justice of the division bench presided by Justice Bhaskar Bhattacharya also, which says, my lord, that the precedent is the one which was delivered earlier. There is also a judgment of Justice Bhaskar.
So I'm telling you that this is what
possibly 2008.
This is what has come. The fourth view was that if the earlier judgment, which was unnoticed in the latter judgment, but appears that the certain provision of the law was not noticed in the earlier judgment, then the latter judgment would prevail if it noticed that particular provision.
Here, this aspect is just the reverse.
Sir,
yes, I follow.
With your case,
I have followed.
To my little knowledge, which I gather was these are the 4 scenarios on a binding precedence.
Yes.
Which would be a binding precedent.
Factually, this 91 judgment is on the point in our.
I tell you very frankly, it is a standalone judgment.
It's 91.
My research does not really tell me that it was anywhere referred or it was anywhere.
So is 2001 perhaps.
Sorry, 91. I am talking about 2001.
Yes, 2001.
Sorry,
Yes,
I said
2001.
91 I did not.
Yes.
But 2001, which he
2000.
cited, I could not find anywhere else. reference.
Because it does not consider the statutory rule. And the fact situation was totally different. Milord, there the suspension of work.
Referred, distinguished কোথাও নেই।
Milord, the suspension of work.
Some high courts have taken that Madras or something.
They may have followed
High
this.
courts have taken note of. Supreme Court, I did not find any judge.
The High Court will be bound. If the factual situation is the same, High Court will be bound by this judgment. But they are not kindly visualize one thing. The fact situation is that universally this was paid. On the finding of the tribunal, I mean the labor tribunal, that the suspension of work was illegal. In that situation, and together with that, the employer in the settlement said, we shall not make any deduction from your provident fund. Employer took upon itself the liability to make payment of the entire money. Milord, though there was no statutory compulsion, Milord, the Supreme Court took the view that therefore this amounts to deemed duty. But I do not know, a social welfare legislation will of course be interpreted in a way favorable to the labor class. But then, I just cited a 2010 judgment of the Supreme Court which says that even in respect of such socio-economic legislation, the intention of the legislature cannot be deviated from in the name of interpretation or in the name of beneficial interpretation. The 2010 I have relied on. I had cited on the line. And that is part of this, my written note.
Judgment O, Annexure O.
Annexure O.
Para 31. Annexure O, Para 31.
Page number nahi jana.
Para 31.
Milord, if your lordship kindly takes me on the last few pages. I'm in my copy there, it's not numbered. I do not know whether in your lordship's copy is paginated. Milord, the last judgment is Dalco Engineering. The last
Dalco
judgment,
Engineering.
Yes, Dalco. Dalco, Milord, paragraph 31. Paragraph 31 at page 391 of that judgment. Dalco Engineering. On the last occasion, I had placed it. Shall I read it out? Paragraph 31.
No, I can read it.
Yes. Levels unintended by the legislature.
Which definition a provident subsistence allowance payment করতে গেলে which the percentage টা আমি কাটছি the weight টা
No, it is on a different score. What it says is the spirit was different. That if the language is very clear and if it puts certain restrictions in the welfare legislation, then in that event, unnecessarily, you should not import by using a canon of interpretation something which is not really in tune with that.
Yes.
So this is what is a very well settled principle. There is no doubt about it.
I am drawing inspiration from this principle on only one aspect. Milord, namely, the Supreme Court did not consider, perhaps it was not placed before you, that there is a liability, statutory liability is created on the employer only for the purpose of deduction from the current wages, not otherwise.
No, that is what you have said.
Therefore, if we
scheme 31 2 or
32
something, you have already
32
said
1.
31 2 or
32 1.
32 1.
Paragraph 32 1.
I was
of the
reverse. 31 2. 32 1.
32.
And I have shown Milord the para 29. Para 29 of the scheme.
29. Kindly read this. 29.
You have to match the energy level of your formidable opponent.
29. Oh, I do. Just a boy. 29. Here is another copy. Not contributions payable by the employer under the scheme shall be at the rate of such and such % of the basic wages, dearness allowance, including the cash value of any food concessions and retaining allowance, if any, payable to each employee to whom the scheme applies. Now kindly come to para 3. The contribution shall be calculated on the basis of basic wages, dearness allowance, including the cash value of any food concession, and retaining allowance, if any, actually drawn during the whole month. Actually drawn during the whole month, whether paid on weekly, or monthly, or fortnightly basis. It has to be actually drawn in the
contention is, yes, definitely, the contribution is attracted on the basic wages. Whether the subsistence allowance comes within the basic wages is your first question. If it does not come, then 29 has no application because it talks about the basic wages. So first endeavor would be to find out what is the meaning of the basic wages. Whether the subsistence allowance comes within the purview thereof. If it comes, I think then the 29 will have an application. If it does not, then definitely it ruled out, it goes out.
We are 29 will have application, but there is another aspect. 32(1). The liability is on the employer. In which situation? When?
The scheme is also here.
Yes, 32(1). That is the scheme. 29 is also part of the scheme. Employer share to be deducted from the members. 32. Recovery of a member's share of contribution. The amount of a member's contribution paid by the employer or a contractor shall, notwithstanding provisions in this scheme or any law for the time being in force or any contract to the contrary, be recoverable by means of deduction from the wages of the member and otherwise, provided that no such deduction may be made from any wages other than that which is paid in respect of the period or part of the period in respect of which the contribution is paid.
So you say is the current.
It's the current.
That has been clarified in 1991.
And this what I submit
clarified in one judgment.
is that 1991. I have annexed that also in my written. 1991 clarifies this that. This means current period.
Still, your junior should not have any sense of remotest sense of any escape from our
No,
mind.
not escape. My learned junior was asking me to show to your lordship once more this 1991 judgment.
That is what I said.
Yes. Perhaps it's not. Your lordship remember?
Hardly escape.
I can't.
My lord, one thing. There was no cessation of membership till the date of superannuation.
Oh, he's not disputing.
So these are the scheme, my lord, it has been said it will go on, my lord, paying once he's a member. Or he's
your written notes of argument.
Your lordship has said not required because that only on that judgment my learned friend was supposed to make argument.
Then we say that if you can file.
He has filed, my lord.
Last time I agreed. Yep.
My lord, one page is there. My lord, I can give it, my lord, to your lordship, my lord. I have prepared for myself.
Written by your client.
My lord, I have prepared it, my lord.
Oh, you prepared it. I have a doubt.
My lord, only one copy. That's why, my lord, I'm giving, my lord, this.
Make a photocopy. And
yes, my lord, I will make a photocopy today.
Lord, I represent the substituted respondent. Lordship, the original respondent died in the during the pendency of the writ petition. Lordship,
who was your
brother. Now, Lordship, he was a 60% handicapped person. Now, Lordship, he joined in the service in the year 1993, and in the year 2001, he, along with other workmen, were suspended in contemplation of disciplinary proceeding.
No, that is, facts are not dispute.
No, Lordship, why I say about 2001?
Then you challenge the order of suspension before the tribunal, the labor tribunal, and this was upheld by it that it is justified. So that was, the suspension was justified. Now
The suspension was justified, but the continuation thereof was not decided.
that if you continued, then it does not mean and get the subsistence allowance, then that will not be regarded as a basic wages. This is what their argument, first, very fundamental argument. If you come under the basic wages, they are out of court. If you do not, then they say that
My lord, at paragraph
impose further liabilities on.
My lord, at paragraph 7 of my written notes, I have stated that the subsistence allowance will also
Given only 2 pages.
Paragraph 7.
Paragraph.
That subsistence allowance will also entail payment of provident fund, Lordship, in terms of the analogy of the Supreme Court judgment which has been relied upon by the authority while disposing of my case by the reasoned order.
Yes.
But Lordship, today, Lordship, we are not on that. Today, Lordship, at the time of my superannuation, what was paid to me was only could have been the basic wage and nothing else, because subsistence allowance I have received all along from 2001 to 2015. In 2015, Lordship, what I received was basic wages. Now, Lordship, in the basic wages definition, Lordship.
No, that has been referred. You have seen. Say 3. He is talking about on duty or on leave,
Lordship.
or holiday.
Yes.
These are the 3.
So there are
on duty has to be understood. 2001 judgment says that if he is under suspension, that he is under the deemed duty.
Lordship.
So he is under the deemed duty.
Lordship.
That is there.
Lordship.
He wanted to distinguish on the parameter of the fact, and then says that no, this parity cannot be brought in this case. We have to consider that.
Lordship. And Lordship, what I say is that while on duty is not the sole criteria in the definition section. Lordship, there are the other words.
The holidays, you are not on leave, you are not on holiday.
Lordship, I was not allowed to work. I was not allowed
to leave. Leave is, sir, leave concept is a different one.
Lordship, the concepts are different one. Lordship, the exact words are not there. But Lordship, kindly consider all emoluments. Lordship, the definition starts with the words all emoluments
which you have received on duty or such something which will be there or on leave.
Yes, narrates everything, and then there is the does not include certain things. So other than which are not, does not include, everything will be within the basic wages definition, Lordship.
He says it will be, but the condition precedent is 3 criteria.
Now, Lordship, will kindly take one document, Lordship, which has not been placed. Page 85 is the document by which, Lordship, I was paid all my dues at the time of my
admitted.
At the time of my superannuation.
Say that as a I would say the model employer, out of good gesture, I have paid both the contributions of the employee and the employer to you.
Lordship, not for that reason, Lordship, I was trying to show that document, Lordship. It says about the payment of wages. That's why, Lordship, I want to say, yes, that is there. That part is there, that the entire contribution has been paid. But what was paid to that period was my net salary. Not subsistence allowance, but net salary. The salary was paid to me. As such, it partakes the character of basic wages, and it will be... Now, Lordship, I have relied upon one division bench judgment of this Honorable Court, Lordship. In that case, Lordship, suspension, contemplation of disciplinary proceeding, Honorable Court injuncted the employer by saying that you cannot give effect to the punishment order. Lordship, punishment order was imposed, the person died, but it could not be given effect because he left in the meantime. Lordship, the Honorable Division Bench of the opinion that every benefit should be given to him. Lordship, here also, Lordship, it could not be given effect. No punishment was ever imposed till my superannuation in 2015.
Yes. Let the written notes of argument filed by the appellant as well as the respondent number 4 be taken on record. The hearing
3, order 41. 73.
That was.
What are the judgment to affirmation matter? Can file an application amendment of the statement matter. The document which has been executed without objection. But both the court held that in the pleading it has been included, therefore it is not considered. I have made this application for amendment statement.
What is that application?
Amendment.
What is that application? What is the number?
And number 3.
Yache district. When original statement. Is a portion, which portion was that the court has refused to look into the documents?
Last page of the trial court judgment.
Tell me the internal page.
Internal page. No, page 47.
These were marked without objection.
Without objection.
The appeal shall be heard on the following subject.
for the respondent.
Appellant is not.
Well, the last occasion, your lordship was pleased to pass an order that the appellant, your lordship pleased to found that there is no merit in the second appeal, and they have prayed before your lordship for some time so that they can vacate the fruit property.
Yes.
Now, on the limited purpose, a notice was served upon me. Madam,
Where is Mr. Pradeep Mukherjee and Ms. Chaitali Mukherjee?
they've served me notice to my client.
Pass over, let them come.
But only one more thing, as I informed by my client, the respondent number 1A has died in the meantime. But I've checked the brief. He has not been substituted. She has not been substituted.
Other heirs?
Yes, I'm for the 229, 1A.
1A. Who is 1A?
The Khandi Mahato, wife of Kriti Mahato.
The wife of
the original plaintiff. Original plaintiff.
Original plaintiff. And who are 1B?
1B, 1A is the wife, 1B is the daughter.
So daughter is already there.
Already
no
there.
amendment.
Yes, yes. But
Only
that's only to
deletion.
inform because she is required to be
Only the deletion
deleted
of
from
the-
No, may I come back Monday? I shall inform her over phone. Much obliged.
77, my lord, I am for the appellant, my lord. The advocate on record got injury in his leg, my lord. So kindly makes it after 2 weeks.
Then let it go out of list. Whenever you feel, then you mention them.
After 2 weeks.
No. An accommodation is sought on behalf of the appellant. Let this matter go out of list. Yes, next.
My lord, I'm for the appellant, led by Mr. Kishore Mukherjee, advocate, and he's suffering from viral fever. Accordingly, I'm praying for a short accommodation for this day only.
Not today.
Lordship, I am for the appellant. Your Lordship, there is a formal defect and inadvertent error, Your Lordship. The appeal is directly from a decree or a judgment, so it will be FAT, Your Lordship. That correction needs to be made. So, if Your Lordship kindly grants me liberty to do that.
Seen the report of the additional stamp reporter put on the reverse of the first page of the memorandum of appeal. Because we don't have a determination.
I'm obliged.
I'm for the respondent, my lord. Plaintiff respondent.
Judgment of affirmation.
Judgment of affirmation, on 2 occasions, my lords were pleased to hear out me, my lord. But there was deficit court fee of rupees 35.
It was not here out. Deficit court fee.
But that,
first day,
I have also, my lord, placed
400 and
initially, my lord, 430, 415.
450.
Thereafter,
You deposited 415 without looking into the record. Then we say 35. now
35 I have
35
deposited.
deposited. So there was no hearing.
No, yes, I have placed my case on last occasion. All right. The suit is for eviction of license and recovery of first possession. I am the license defendant. Both the court held against me. The only point is that on the last occasion I have also submitted before filing the suit, the appellant licensor in 2013 issued a notice recognizing me as tenant. In the letter itself, it was addressed by him to Mr. So-and-so within bracket tenant. Subsequently, in 2014, he issued second notice. After cancelling that notice, the last notice was served upon me. In the same notice, he has described me as licensee. Thereafter, suit was filed. But in the suit, when he was cross-examined, he has changed his stand. Sometimes he described me as tenant, sometimes he had described me as license.
Have you produced any rent receipt?
No.
Showing the
And there was a alleged registered agreement for limit to 2004 to 2014. After expiry of that lease period, he served the notice. Thereafter, suit was filed.
You know, under the even of West Bengal Constituency Act, if the earlier notice is against, subsequently proceeded by another notice, it will be impliedly deemed to have withdrawn. Here they have cancelled that wrongly, they have served the notice. You are not a tenant, now you are a licensee,
But
and they rectified their mistake.
In course of
But,
evidence,
not a single payment of rent you could
that
produce.
was not there. But in course of evidence, he has admitted in cross-examination that I was inducted as tenant. Like
But rent was
no,
approved.
indicit was filed.
So without consideration, can there be a tenancy? Tell me.
May I place that piece of evidence of the?
I am asking you, that's a law. Section 105 of the Transfer of Property Act says, if anything is transfer of the human property for use and enjoyment, must be in lieu of consideration. What is the consideration?
That
That's
was
the rent.
My case as pleaded in the written statement as well as I.
Which court?
This is Siuri, Birbhum.
Mufassil court.
The first court, Siuri.
Mufassil courts. So Mufassil pleading, Mufassil evidence should not be strictly interpreted. Supreme Court has also said. Agreement was proved, marked without objection. You are a literate person. You know what is the content of the agreement. Then what more, sir?
There were other points. The suit property was unpartitioned. There was some mistake in the mentioning the Khotian number, etc.
That's a good for execution. Take that, please. Weakness of the property. Yes, my brother will deliver a judgment.
Right.
Follow the list, it will appear.
Kindly recall this matter, my lord. The appellant is the grandfather of the respondent. Your lordship, the eviction of a suit for eviction of a licensee. Your lordship, on the first occasion, lordship, for the shortening the issue, your lordship asked me to give a notice to the respondent so the matter can be amicably settled. When I've talked with the client, The appellant is 95 years old. My lord, it's true. 99 years old. It's true, my lord. It is the best way the matter can be resolved. The problem is, I gave the notice in the address given in the suit of the suit property. But what I have been told, my lord, the lessee has, my lord, left the suit property, keeping the same on a lock and key. So he will not receive the notice. He has the another address. But lordship, unless and until some sort of leave is recorded to give the notice to him, my lord, to the new address.
Of your own, we are concerned with his presence. If he comes and appears, no difficulty.
My lord, then may I give another notice to the
We are giving you not this week.
my lord, because the appellant is 99 years old. It is
What?
my lord, I'm
What? That suppose if the appeal remains
after your lordship's
execution, you do not know how.
my lord, after your lordship's what my lord, I convinced my client that is the best endeavor your lordships has taken to get the matter resolved, my lord. By this, I'm giving another notice and coming back. Let the matter retain its position, my lord.
Yes, not this week. We are saying adjourn for a week. We are saying.
Man.
I am for the appellate, my lord. My lord, I am for the Mr. Anshuman Chakraborty is appearing for the respondent. There is a bereavement in his family. His father has expired a few days back.
Which one?
83, your lordship. I'm praying if this matter can be kept anytime after 12th.
There's no right of audience unless the appeal is admitted. This is the second appeal. We will adjourn the application in the event we admit.
My lord, kindly, my lord, then my lord, next.
What?
My lord, Monday,
You
my
are
lord.
not ready that.
My lord, Mr. Roy, my lord, is leading me. Pathrapratim Roy, my lord.
That shows that you really wanted an adjournment.
No, I was informed, my lord. I was informed, my lord.
On his shoulder.
No, my lord. I was informed, my lord, prior, my lord, earlier, my lord, that an adjournment was to be sought for before your lordships. My lord, kindly keeps it on Monday, my lord. I'll
The name of the respondent number 123 does not find place in the certified copy of the decree of both the court. From where you got it? 123? No application for addition. Name of the sole respondent in the first appellate court does not find.
Yes, subsequently, my lord, after the decree, my lord, this person died.
Then will you not take out an application seeking leave to proceed against them? Can you do it in this way?
I should have. I should have. I should have.
That's the procedure.
I should have.
Let the matter go out of this.
The sole respondent was, my lord, Krishnalal Datto.
They let the matter go out of the taking. Yes.
84, my lord. I'm not briefed in this, my lord. Mr. Roy is, my lord. That is appearing, my lord. He's, my lord, on his legs. 84.
Which Mr. Roy?
Well, Pathrapratim Roy.
Why is not appearing?
Well, he's on his legs, my lord.
Let the matter go out of.
My lord, kindly, my lord, keeps it, my lord. My lord, a day's accommodation. My lord, kindly a day's accommodation. I ensure, my lord, the advocate on record, my lord, and Mr. Roy is here, my lord. Kindly, my lord.
Can you pass over then next?
Great.
May it please your lordship. My lord, this is a matter, my lord, basically arising out of a surface proceedings. Appellant before your lordship is a bank, and the suit is not maintainable. Basically, in view of Section 34 of the Surface Act, that was a challenge made, and the suit was, my lord, dismissed on that ground. Against that, the plaintiff filed the appeal, and the appeal court has passed the order, which is impugned order, my lord. In the stay application, it's, my lord, at page 152, my lord. The trials court order is at page 100 and appeals court order is at 152.
Now tell me whether the second appeal lies.
Well,
after the judgment of the special bench, presided over by the Honorable Justice Somense, Order 7, Rule 11 of the Code of Procedure was allowed. Meaning thereby the plaintiff was rejected. Then definitely it comes under the definition of a decree. Appeal is the proper mode. Appellate court reversed the judgment. Meaning thereby the order rejecting the plaintiff was dismissed. Then whether the further appeal lies, there was
Lord, may I come back after considering that judgment?
special bench judgment
My lord.
of this year
My lord. I have not, but may I go through and consider that
on this point itself.
on this point. Yes.
Rejection of a plaintiff is a decree. Then rejecting order 7, rule 11 is not a decree. Find out. Adjourn or
And at least a week's accommodation be given.
let this matter be listed on next Friday.
Right, please, madam. So this is my appeal arising out of order dated September 12, 2024, madam, passed by the learned Civil Judge Senior Division, madam, in a suit for declaration, injunction, and seeking delivery up of a registered instrument, my lord. Registered.
What?
My lord, suit, my lord. I am the petitioner. The appellant before your lordship is the respondent number 2, defendant number 2 in the suit.
Defendant number 2.
Defendant number 2, my lord. And respondent number 1 before your lordship, my lord, is the plaintiff in the suit. The respondent number 1 filed a plaint, my lord, suit, my lord, seeking delivery up and cancellation of a deed of partition of the year 2008, registered deed of partition, and declaratory relief and injunction. In that, my lord, the learned trial court has passed a drastic order injuncting me, my lord, in respect of properties when none of the properties lie within the jurisdiction of the learned court. There are the suits which are already pending, my lord. And my lord, when I took this,
None of the properties means
lordship will kindly see the schedule over which I have been injuncted. My lord, the plaint lordship will find starts at page 605, which is in third volume. Third volume.
Prior to that, my lord, I would like to bring it to your lordship's notice that Mr. Aniruddha Chatterjee is appearing on behalf of respondent number 1. My lord, he has left the court for some personal difficulty, my lord. So if my lord kindly pleases to keep the matter on the next day, any day your lordship's
My lord,
desire.
matter is there on Monday. My learned friend is proceeding, my lord. Then
But
again,
they
this
have-
application will become,
but they have
lordship will
not-
recollect this same matter where Mr. Chatterjee had taken the point that my first application became infructuous, my lord, because the ad interim order was extended.
this is
My lord, that
Yes.
matter. Now that matters.
My lord, in the memo, they have not challenged the extension order. They have filed a separate can application.
Well, lordship, can 2 is there.
But can 2 will not
We will
do.
not
Grateful, my lord. Lordship, in fact, I wanted, lordship says you simply file a can. Lordship will kindly recall.
No.
Extension.
My lord, this was my lord.
Page memo.
My lord, this was my lord's observation, my lord, that I came.
Under no, but even under the dream we cannot say.
I'm so
I
grateful.
think you have wrongly understood it.
I'm so grateful.
By no stretch of imagination we can say can.
My lord,
Never. I
then
think
my
you
lord,
are
then my lord,
wrongly
then my lord, I
understood.
misunderstood.
One-page memo.
Lord, I then
But
misunderstood.
then my humble submission
My
would
lord,
be
will
let
kindly,
it
my
be
lord, will kindly.
extended on the next day, my lord, and he can file a separate supplementary memo, my lord. Whatever your lordships please.
Supplementary memo.
My lord.
Again, you will create a confusion.
It cannot be supplementary. My lord. Whatever your lordship please.
My lord, the matter is fixed before the learned trial court again on Monday, my lord. And my lord, the suit, lordship will kindly bear with.
Difficulty again, I'm saying the matter is
Again-
pending before the larger bench, to which I am bringing that larger bench.
an application filing with
The points of reference is whether an independent appeal has to be filed against each order of extension, even if the parent order is already challenged by filing an appeal.
Filing an
This is what is the point.
My lord, my lord, that's what had fallen from your lordship's, my
The
lord.
process. So I ought to obviate that till this time when no final decision has been taken. Every extension, why you wanted?
No, my lord, I shall. That, my lord, I shall do. Only, my lord, will kindly bear with me for a minute. My lord, a suit which is filed on 12th of September 2024 has been made ex parte against me on 24th September, within 12 days.
Because that the order which you have challenged was of a limited duration.
My suit
After
has
extended.
no, my lord. I'm not on that, my lord. Suit is has been transferred to ex parte board against me within 12 days of filing of suit. That kind of drastic order is being passed, my lord.
Suit has been transferred
Yes,
to
my
ex
lord.
parte.
My suit filed on
12 days of
within
filing.
12 days of filing of suit. Suit filed on 12th of September. My lord will kindly see my second can 2. Lordship will see the kind of order which is being passed. Can 2, my lord will kindly take. My lord will see order dated 7th of November. Sorry, 24th. Sorry, 24th. 24th of 24th of September. 24th September. My lord, suit filed on 12th of September. Now, lordship will kindly see last part of 24th September order.
No.
Can do it.
No.
Well, page 26 of my can 2, my lord. Hence, the suit shall proceed ex parte against defendant number 2, who is the plaintiff, sorry, the appellant before your lordship.
You have a right to file written statement within 30 days. If the right has not extinguished, how can he say that?
So my lord, this is how this suit. Lordship will kindly see this is how the suit is.
Submission.
Sorry.
My lord, very respectfully submitting, my lord. He needs to challenge this order for that.
Of course, I will,
He
my
needs
lord.
to challenge
Lordship,
this
I'm
order.
just showing the
He
conduct.
cannot ventilate his grievance.
My lord, I will, my lord, I will file it. My lord, I will file it.
Giving them a premium.
Sorry, my lord, I will file it.
Just remind us on Tuesday. This back.
My lord,
File it.
my lord.
We'll see to it.
Tuesday.
Grateful, my lord.
This kind of a nepotism and this kind of a favoritism, how can it be allowed?
Grateful, my lord.
Suit filed on 12th of September, on 24th of September, right to contest goes. When Order 8 Rule 1 says 30 days
30
from
days.
the date of
Obliged,
the
man.
summons,
Obliged.
he has a right to file. Within 30 days, right extinguished. Which judge?
My lord, will see a division. My lord, will see memo. My lord, I will not name the judge. Lordship will kindly.
No. Have you disclosed the name in memo?
Yes.
We'll read to it.
Need to see what the obligations are going to be.
None of the properties within the jurisdiction.
No, that is a
That's my
different
lord,
issue.
Yeah.
To something which is really
Limited petition. That is need to refuse to take. You to file an application again. How much? Baaki guys.
Grateful. My lord, Tuesday, lordships.
in your memo.
My lord, I'll have to file 2 more because Monday again that order will be extended.
File it immediately. Come.
Grateful.
Grateful. Yes, call the next.
Before